fine.
Calling the matter Mazzetti Management Services and another versus amaBhungane Center for Investigative Journalism, case number 2023/050131.
Please, my Lord, I appear for the applicants together with a number of colleagues. May I ask your Lordship to turn to page 97 of our heads?
Yes. Yes, I have it.
You would see that right at the end of the heads, there is a list of colleagues who have prepared and co-signed the heads. Present today for the applicants, are myself, Mr. Stratton, Mr. Sisilana, Mr. Wild, and Ms. Maya.
Right.
The rest of the colleagues are not here, they asked me to extend our apology to the Lordship.
The Furnishing Committee of the Court thanks them for their absence.
The Court, my Lord, I appear for the respondents in this matter, with only Ms. Goodman to assist me, but we will soldier on bravely.
Thank you, Mr. Butler.
As it pleases the Court, Michael Power, on behalf of the first, third, and QRI. The Lord, I appear in the absence of Mr. Bishop, who is leading on this matter because I'm here.
Thank you.
May it please the Court, I'm here for the fourth Amicus, Corruption Watch, together with Mr. Masvikwa and Mr. C.
Thank you very much, Mr. Ethel. Right. Thank you, gentlemen. Thank you, ladies. Right. Let's get the preliminaries out of the way. You've objected to the latest chapter. Yeah. I gather what's in that affidavit is an extract from something that's in the public domain as well. Does that mean I'm the only one on the planet who's not allowed to see it?
No, my Lord. What we have done since, my Lord, is to prepare a responding affidavit, which is presently being commissioned, because parts of the annexures to the affidavit placed by way of a notice of motion does not include the complete picture of the transcript of the articles.
Well, before we go down that road, Mr. Butland, do we really need it? I'm really not all that enthusiastic about adding an extra floral decoration to what you already got.
No, my Lord, it really says in terms, the quote really says in terms what is made clear by the rest of the papers. And so
it just seems more of what you really got on.
Indeed, indeed. So we would have thought there would be no objection, but if it's going to cause...
Should we leave it out?
Let's leave it out. Thank you.
Okay, so that's that done. Right, are there any other preliminaries?
Lord, as a formality, the fourth amicus needs to be admitted as a point.
Yes, I think that goes for all of the amicus. So it is by consent, so such an order follows. Thank you.
Yes.
Right. Then let us then get this matter in order. The next thing that we need to talk about is this so-called counter-application. Which one of you is going to deal with that?
Lord, it was going to Mr. Sisilana, but he tells me that all that he would have wanted
If I understand 612C properly, the only proper business of this hearing is to determine whether or not the order that you have got is justified. It doesn't seem to me to be appropriate that you're entitled to look for additional
separate terms. It's a relief which refines in the main ex parte application. And the causes of complaint are not different They remain the same, except that the refined causes of action in the counter application are those that arise from the version put up by the respondents in their answering affidavit.
Well, look, can I try and make this simpler? I'm not going to allow it. I think it's clearly irregular. I don't care what you've said in the affidavits, but I'm not going to entertain alternative relief. I'm not sure that I understand your arguments in the whole, because in some parts of the heads it suggested that it doesn't amend the notice of motion. In others, it suggests that it's fresh and new. So I don't know how we resolve that anomaly. Perhaps we don't need to. But as far as I'm concerned, we don't need it. It's an unnecessary accretion to what we've got. And what I am of the view of, unless you persuade me to the contrary, is that the proper application of a 612C process is to look at what you've got. If you want to abandon some of it, that's one thing, but I'm not sure that you're entitled to do anything more. And let's deal with what was ordered in the motion court, urgent motion court, and ignore the accretions that really add nothing to the true controversy.
My Lord, we will take your guidance on that score, and I will reflect on it, and we will make a final decision and convey to your Lordship in due course.
Yeah.
I understand your Lordship's provisional views on it.
Yes. I'm telling you what I propose to do unless you persuade me otherwise. I think it's actually quite a cheek.
Lord, I was going to make two submissions so that your Lordship should reflect on it.
Yes.
And understand that your Lordship has a view on it. But the 2 points that I'd like to make to ask your Lordship to reflect on it is that your Lordship would have seen that the drift of our main contention is that whereas here your Lordship is dealing with the case of intercepting and conflicting constitutional interest. In the final analysis, your Lordship would have to engage in a balancing exercise, obviously based on the profound principle of public interest. And in that sense, your Lordship would be called upon to exercise some sort of a discretion to see whether or not the main relief sought in the main application should or should not be granted. In that context, your Lordship's discretion is broad and wide, and your Lordship's interest will take into account a number of factors, including the type of factors which would provide a reasonable balance, protecting, on the one hand, the interests in the media and protection of sources of information asserted by the respondents, and the interest asserted by the applicants to privacy, protection of confidential information, as well as privileged information. And if on the papers your Lordship comes to the conclusion that the balancing exercise requires that both interests must be protected, the counter application provides a reasonable basis on which your Lordship would consider the ground of a middle ground type of an order, such as we have suggested in the Crown Court application, and which provides for the protection of the documents, providing at the same time the applicant's access thereto, so that as and when the respondents seek to publish further articles as they intimate they intend to do, then the applicants will have access to those documents, protecting the confidentiality on both sides.
I appreciate all of that. As a proposition of principle, I don't have any difficulty with that. My difficulty is more elementary. I take the view that as a matter of procedure, you're not entitled to do so. The objection's been made, and Mr. Butler needs to know whether he must deal with it or not. So I don't think I can defer the decision.
And I would not go to the terms of the counter application chapter by chapter, paragraph by paragraph. I'd seek to persuade your lordship that even on the main papers that are subject of the reconsideration, the lordship would be entitled to exercise that discretion with a view to balance both competing and conflicting interests.
All right. Thank you. Thank
My
you.
Lord,
Anything else to add?
The only remaining thing is one of time. We understand that we only have today, my Lord, to argue this case.
Well, I don't think we need to give a guillotine to each other. I've had a chance to look at all the heads. There's no need to regurgitate what doesn't need to be regurgitated. We'll get through it by the end of the day. If we need to sit late, we'll do so.
Indulgence.
Right.
But what remains from our side is to indicate to His Lordship that I'll do most of the argument, and I don't plan to repeat all of the submissions we made in our heads. I'd like to reflect only on those key parts which we believe arise for consideration to the respondents' heads of argument.
Well, I promise I'll give you an opportunity to answer the questions.
As your Lordship pleases.
Thank you.
I'll pay careful attention to the questions from the bench so that the heat from the bench does not blow me out of this court, my Lord.
All right. Thank you.
What I would wish to indicate up front, my Lord, is that Mr. Stratton will do some argument relating to parts of our head, and those would be the issues relating to sections Q, my Lord. If your Lordship is at page 2 of our heads,
Yes.
it will be section Q, section
moment.
R, and section S, my Lord.
Yes. Very well.
If I may start, my Lord,
Before you do start, shouldn't I hear Mr. Budlander first? This is his application, isn't it?
my Lord,
Have you come to a different arrangement?
I had suggested to my learned friend that it may be appropriate because he has to persuade your lordship that this order is justified.
Yes.
And in those circumstances, it perhaps would be appropriate for him to start. I'm certainly ready to
No,
start.
I'm happy to do so. I just assumed the default position was the other way around.
There was apparently some debate in front of your lordship's brother, Jans van Nieuwenhuizen, about that. And in the end, what was done in that case is that the applicant started. And we're perfectly comfortable with that.
Okay.
Thank you, my lord.
So let's just sort out when the amici get an opportunity to
Yes,
come
I
in.
think the agreement we've reached is that the amici will know what they shouldn't repeat. In the
Yes.
extraordinarily unlikely event that I need to say something about the amici, I
Yes.
will, but I can't conceive of it at this point.
No, that seems sensible. I'm happy with that.
Thank you.
Right, very well. Thank you, Mr. Maleka. Please go
thank
ahead.
you, my Lord. Lord, whilst our heads have a chapter devoted to introduction, which your Lordship would find at page 4 of our heads, case line 12-14, my Lord, I propose
Just let me get clarity
page 13 under section B, and the relevant chapter is relevant factual metrics and chronology.
Well, then we're looking at two different documents.
Dash 23, my lord.
Dash.
23.
Oh, I see. Yes, that's part B. All right. Okay. I'm with you now. Thank you.
Thank you, my lord. And my lord, I'm not going to get into the introductory section, and I take it as read, my lord. But what we would like to do in the course of our oral submission, my lord, is to explore some few submissions relating to part B, my lord. And your lordship knows that the heads have been accompanied by a chronology, which we hope will be of assistance to his lordship. And that chronology, my lord, is at case line 12-113.
I think we pretty much know what the factual situation is. As you have it, Fanika stole the documents.
Yes, ma'am.
Whether steal is correctly the term to use is unimportant for the moment. They're out there. The respondent has had access to them. They've used them. I think all of that is pretty much taken as read.
What is in issue, my lord, is that what has been used thus far is portion, but not the whole of the document. So that there is more which is in the possession and control of the respondents, which in due course on their own approach will become a subject matter of publication by them. One important issue I would emphasize on that score is when you read the articles that have been published, their provenance and the analysis contained in the application is the contents of the stolen documentation. There is nothing by means of investigative journalism which derive its own source from third-party information. All that His Lordship would find on the reading and analysis of the articles, DVR 5A to D, is an analysis of the contents of the stolen documents, around which the respondents express conclusions and draw inferences around the alleged improper conduct of the Moti Group and the active role players in that group. So that we would submit that Your Lordship would take into account that what the respondents plan to do in due course is to rely on the contents of the documents that have been stolen in order to repeat that type of application based solely on the contents of the stolen documents. That's the first thing. The second thing that we would like Your Lordship to consider is that the respondent's approach is to justify the continued possession and use of the stolen documents on the basis that they have derived them not only from but a source of the kind which enjoys protection either as a whistleblower or as a person in witness protection scheme under the Witness Protection Act, my lord. On that score, my lord, we would respectfully submit that the respondents have not shown any factual basis to come to the conclusion that Mr. Van Niekerk or Mr. Lusky or whoever their confidential source of information might be is a person who is a whistleblower, whether in terms of the provisions of Section 159 of the Companies Act or on the provisions of Section 5 and 7 of the Protected Disclosures Act, my lord. Frankly, my lord.
Well, do they actually need to rely on that proposition? Isn't their real case far simpler? Is they claim that on the strength of pretty well-known norms, a sacrosanct aspect of a journalist's function is never to disclose the source, and the courts have made it plain that that proposition is valid, subject to the fact that it's not absolute, and that where the public interest requires that disclosure, then they can't invoke it. Isn't that really the heart of their case? Anything else is just a frill.
It is, my lord. What we would ask your lordship to mark up for further considerations as we make our submissions are two things. One is that the right they are set to protect so-called confidential information is not absolute. It is subject to a qualification. Your lordship knows that both parties referred to the Bosasa case judgment by Justice Stoker. And your lordship would recall that the phrase used in that judgment, which is a different way of saying that when you are said that right, you cannot do it. The learned judge adopts the phrase blanket reliance on Section 16. And the learned judge went on, my lord, to set out the exception to that rule. So there is a general rule, as the lordship says, but the rule is not absolute, it is subject to qualifications. He was saying the same thing as was said by, I think it was Justice Oregon in Holomesa, my lord. But the real point is this: when we come to our submission on the balancing factor, we will ask your lordship to consider that on the facts, there is no evidence at all that Mr. Van Niekerk was someone who was entitled not only to steal the documents, but also disclose them to third parties such as the respondents. The second point we would like your lordship to consider going forward, and we may have to return to it when we deal with is that Mr. Van Niekerk was not driven by any public. He was driven by the desire to reveal kind of information within the Moti Group. We don't know what his motive is, but quite clearly on the version put up by the applicants, which is not disputed by the respondents, is that he was not driven by their civic duty. We will take your lordship to the two judgments we rely on, one of which is highly instructive from the facts, the British Steel Corporation case, my lord, which indicates that where someone takes information belonging to a corporation, not driven by a civic duty, and takes it to third parties, the balancing exercise will have to be weighed in favor of those who seek not only to retrieve the confidential corporate information, but also in disclosing the source. Lord, we're not asking your lordship to order the respondents to disclose their confidential source. We merely make the point that it is common cause on the facts that the source can hardly be confidential, because it is quite clear on the version of the applicants, which is not disputed. Van Niekerk is the source. Liski is the source. And therefore...
Well, if it's so clear, then what's the fuss about?
Well, that's the point.
If the only reasonable inference to draw is that Van Niekerk is the source either directly to the respondent or via the sentry, then, well, So what?
Well, the point is then you cannot
What's the-
rely on refusal to return the documents.
Well, that doesn't really follow, does it? You know,
That's what-
in an unfair competition context, there's a whole range of dynamics which make that proposition the primary. But can't follow logically in the context of a media agent because of the very balancing act which you've listed as anterior to these considerations. So I'm happy to accept, for the purposes of the argument, that Van Niekerk Malafide copied the documents and for nefarious reasons he's had to put them on YouTube or whatever the case might be. I don't think you need to belabor that.
Thank you, Malone.
He's no part of this matter. The elephant in the room is whether any contamination that you can justifiably attribute to his behavior contaminates the behavior of the respondent, who, without belaboring that point, is performing a recognized prima facie public service in publishing matters of public interest.
Yes. My Lord, I'm grateful that I don't have to spend much time on those matters of fact.
Yeah. Why don't we I'm very curious to know, to put it in context, is what the judge in the urgent court was told. I've seen the heads which were filed in that proceeding, and I presume that that is not the full purpose of what was said to the judge. Given the fact that it was an ex parte application, I would like to know what was said to the judge to persuade him that the various cases dead in point against the relief sought were distinguishable in his view. What did he have to say about Avula? What did he have to say about Wastek?
Yes.
What did he have to say about SAA versus BDFM?
Yes.
How on earth did he manage to decide that it was appropriate to grant this relief ex parte if he'd applied his mind to those disclosures which ethically should have been made available to him?
Yes.
How did that happen?
My Lord, I was not in the agent court, but I can
Yes.
make submissions on
Yes.
the papers as they
Yes.
are.
Well, let's just look at that, because I need help to understand this. Between February and April, on 3 occasions, there's publication of disparaging nature.
Yes.
Throughout that period, the respondent and the applicant are either in direct contact or in contact via their attorneys about what they want to publish, seeking questions to be answered, and indicating what the position is. The high point is when the respondent's attorneys make the point explicitly that the tone of your letter suggests that you're plotting to bring an ex parte application. We give you an unequivocal undertaking we will not in any way destroy or dispose of the documentation. How on earth, on that background of over 3 months, could anybody have contemplated that an ex parte application in camera nogal was appropriate? Help me understand that.
Well, my Lord, let me deal with the question of the application in camera. And the point that we made in our heads, which I'd like to emphasize now that His Lordship is raising this concern, is that Your Lordship knows that What the applicants were seeking to do at that point in time is to protect information which they asserted was confidential.
I read what they said very carefully, and just look at the case that was put there. They said, if we give notice to them, they will destroy or conceal the documentation, notwithstanding the undertaking. Just have a look at what that means. This isn't an application dealing with a thief who might want to destroy the evidence of his unlawful behavior. This is a newspaper whose function it is to publish, has published, and I don't know if national media versus Bogoshi is tattooed on the forearm of every investigative journalist. But I'm pretty sure they're pretty familiar with the fact that that case in particular makes it quite clear that woe betide the journalist who publishes a defamatory statement that turns out to be untrue. On a scale between 100 and minus 100, what are the probabilities of a journalist destroying the only evidence that is available to demonstrate that he acted bona fide and reasonably? I mean, the needle of probability must be pretty close to minus 100. So how on earth was this ex parte application justified?
Lord, may I take your lordship to the orders, because
Sorry,
the orders
Yes.
were sought in the
yes, please take me there. I'll find that in volume 1, shall I?
I think so, my lord. My lord is
I have the order starting at 001-8.
This is the order. Yeah. My lord, I am assured that the order that I wanted to take his lordship to is at 08-5.
Okay.
It was annexed to the application for reconsideration.
All right. Oh, yes, right. Identical document. There we are. Got it.
Indeed, my lord. My lord, can I ask your lordship to reflect on paragraph 2? The paragraph deals with the return of the documents, my lord. And the submission that we would wish to develop, my lord, subject to your lordship's guidance, is the fact that the applicants have every legal interest to procure information in the hands of third parties, including which belongs to them and which has been stolen from them. And therefore, the learned judge in the ex parte proceedings was entitled to consider that order, my lord. And if here, my lord, in the course of the reconsideration proceedings, we are able to persuade his lordship that that information ought to be returned to the applicants, we would respectfully submit, my lord, that the learned judge properly considered that order based on the facts presented to him. We now know, my lord, By the way, my lord, what I'm going to do when I make submissions on this call is to contrast the conduct of the respondents before his lordship with the conduct of the respondents in the Bosasa matter, as well as the conduct of the media in the British Corporation Steel matter, and to telescope our submissions on that score. We would show that in the Bosasa case, the media produced by way of discovery and request for further information the very documents which were stolen from Bosasa for purposes of litigation in the British Steel Corporation mode. Granada TV accepted that the documents were stolen from British Steel Corporation. When the application was launched for the return of those documents, it conceded that the documents belonged to the corporation and it returned them. The only issue which was called for determination by the High Court, the Court of Appeal, and the House of Lords was whether the media was entitled to rely on protection of third-party sources of information, not to reveal who those sources were. But as a matter of fact, in both cases, there was production, and at least in one case, there was a return of the documentation.
Well, I'm not sure what the exact point is you want to make in regard to the Granada case. The fact that that was conceded suggests that the point didn't need to be decided.
Yes.
So how does it help us?
Well, it helps us on this score, my lord, and I'll take your lordship to certain passages, my lord, that when you have an owner or possessor of documents which are sought to be used in order to reflect some alleged unlawful or improper conduct on the part of the owner of the documents, the owner of the documents is entitled to return of those documents. The second point we would like to make, Lord, in this case, which was not an issue in the Granada case, is that here, my lord, you're dealing with the media which publish and has expressed an intention to continue to publish information based on the documents that were stolen. And yet it does not want to make available those documents to the applicants for consideration so that they can express a fair response to the articles sought to be published.
Let me help me with this rather practical aspect. None of the documents which Van Niekerk supposedly stole are missing. He took some copies, so there's been no deprivation of property. Never mind the legal debate about whether that means this can't be theft. I'm not concerned with that. How are you prejudiced by having the actual copies removed from your control? I understand the concern you have about what they're being used for, but if they give you back the documents and say these are the ones we used to write the February article and these are the ones for the next one and so forth, what do you actually do with that?
My lord, we would respectfully ask your lordship to reconsider the proposition that there has not been deprivation of property.
There's not been?
There has not been deprivation of property.
Yeah.
There has, in fact, been a deprivation, my lord. Because
what you deprived of is your confidentiality.
Indeed, my lord.
But it's not the legal point. That's why I said I'm ignoring that. I'm not concerned about the niceties of whether there's no deprivation of property. You say, give me back these documents, which you've consistently refused to tell me which ones you're using. so that I can deal with it? Or what exactly do you want to deal with it? You've got all of these things. They've said ABC, they've made quotations. You surely must have the very things they're referring to.
Yes. My Lord, may I ask your Lordship to consider the fact that what was taken from the applicants is not mere blank documents. What was taken from the applicants is documentation containing information.
Yeah.
And therefore, the applicants, as a matter of law, are entitled to protect the documents themselves and information in them. And that is why when Mr. Stratton addresses your Lordship, he will tell his Lordship that what the applicants are concerned with is data in the widest sense of the word and definition in the Cybercrime Act. Because data may be manifest and may be stored in different formats. And so, it is in that context, my Lord, that the applicants are entitled to say, you have taken a document which reflects my private information. I'm entitled to protect my private information. It is that information contained in the document which I want you to return because it has been taken away from me unlawfully.
This proposition. What you seek to do is to aver that information which is confidential to you has been misappropriated. I understand why one would want to prevent further publication. But what is the practical utility in telling them constructively, presumably, that they must return the copies, the digital copies of the material that they've had access to? There doesn't seem to be any practical utility for that. It's really just a splitting of the relief you seek is stop using our information. Isn't that really what it's about? Isn't the re vindicatio dimension a red herring?
Indeed, my Lord, it has that element, my Lord. It does, with respect to Lordship is correct, have that element, my Lord. And it is that element we would submit the applicants are entitled to explore before His Lordship.
You see, if you had obtained the order on this premise to say you've had access to our confidential information, you've used it to publish defamatory remarks, we need you to stop doing so. You don't really need the re vindicatio aspect at all in order to achieve what you really want. The very substratum of the relief you say you require is a cessation of publication having regard to information that can be derived from your confidential information. This re vindicatio aspect is a fifth wheel on the wagon.
Yes, my Lord. I'll think about it, my Lord, but I'd like to complete my submission on that score.
Sorry if I've interrupted.
No, my Lord. I'd rather answer your Lordship's question than to debate my own popular argument, which we all know, my Lord, because I'm here to assist your Lordship.
Yes.
But the point is this, my Lord. On that score, we would simply ask your Lordship to consider that someone who owns proprietary right or interest is entitled to control and determine its destiny. And therefore, my Lord, the fact that your Lordship may make an order that the respondents would not be entitled to publish any article relating to and relying on the documents is not enough comfort for the applicants. They're entitled to say that that is an information belonging to them, They are entitled to regulate how that information should go into the hands of third parties, and they're entitled to say the information has gotten into the hands of third parties unlawfully, and they want a return of that information. And so, my lord, on that issue, we will think about it, but we would like to make it quite clear that as a matter of law, as we understand it, the applicants are entitled to dictate the destiny of the information belonging to them. My lord, I was at the order itself.
Yes.
In relation to paragraphs 2.9, look at yes, my lord. May I again interrupt myself, my lord, and make this point? That your lordship knows from the confidential affidavits, and I'm not going to refer to them chapter by chapter, my lord, because we are in open proceedings. But the point made by the applicants, or relying on both those two affidavits, is that there is information in the trove that is now in the possession of the respondents, which deals with personal information, which deals with privileged and proprietary information, none of which would be of journalistic interest to the respondents. And if that information is available to them and does not assist in the execution of their duties as journalists, there is no need for that information to remain in their possession.
This is information which you've ascertained reliably has been copied from your own database. Have access to any of the documents you've described. Maybe they do and maybe they don't.
Yes, my lord.
Yeah, that's the high point.
What they don't say, my lord, on their papers, and we'll invite our learned friends to tell his lordship, that they say that information is not in their possession or accessible to them.
Yes.
What your lordship would respectfully submit is to look at the high watermark of their version. They say that information, it is stored in some two servers abroad, one of which is under their control. The other is not under their control. Presumably it's under the control of their sister, Century Middlewood. And we would... I'll get to what Mr. Duncan asked me to refer his lordship to. But the point that I was making, my lord, is that it can hardly be open to them to suggest that they don't have access to that information. Because we know that by conduct and pattern, they rely on that information to publish the journalist's Middlewood. And like any other journalist who is in possession of trove of information, Middlewood, the series of publication acquire a journalistic descriptive nature. We now know that in the British Steel Corporation, they were called the Steel Papers. We now know that in the most recent history of this country, they were you're dealing with the so-called Moti files. Watch the space going forward. And so, my lord, we would submit that on an undisputed version of the applicants, they have access to the information. But let me pause here, my lord, and ask your lordship to look at what Mr. Duncan asks me to...
Take your time.
And my lord, I would ask your lordship to consider the reference to the supplementary affidavit of the respondents at case line 9-50, paragraph 4.1, where the respondents say, and I quote, the respondents have access to large quantity of documents
Sorry, what
concerning
paragraph?
the Moti Group. It's paragraph 4.1, my lord.
Bear with me. Yes, I have it.
And your lordship will see that there is an admission by them that they have access to a large quantity of documents concerning the Moti Group, my lord. And my lord, even in the articles they have published, they say so in terms, my lord.
Your proposition is that under the best possible circumstances, it couldn't reasonably be expected of you to identify exactly what they have.
Indeed. Especially when they don't present you with the documents concerned for you to consider.
And you've been given no assurance that, let's call it intimate documentation,
Indeed.
is not available to them,
Indeed.
or that they will give you undertakings about not using it.
Indeed. Indeed. And my lord, again, this is to belabor the point, but it's to add context to the proposition. We know, my lord, that Mr. Van Niekerk was employed as a legal advisor for the Moti Group. We know that the applicants give chapter and verse of his functions and duties as a legal advisor. And they make the point that information identified, or some of it, identified in the confidential affidavits include privileged information. And, my lord, that privilege is not the one belonging to Mr. Van Niekerk. It is a privilege belonging to the companies in the Moti Group. They have not waived that privilege. Far from it, they asserted no. And we would submit that that is information which can hardly be of journalistic value to the respondents, which ought to be returned to the applicants. And that case is made out in the founding papers before His Lordship, Mr. Justice Holland Mutamid. And, my lord, I was going to take your lordship to parts of the order, my lord.
Yes.
My lord, I was at 08-6.
Yes, I have it.
And what I wish to point out, my lord, is that the sub-paragraphs 2.1 to 2.4 were considered by Mr. Justice Van Nieuwenhuizen on the return date, my lord, and he duly amended those paragraphs in order to not impose an undue burden on the respondents to return the documents within a period of 48 hours, my lord. The point is that the respondents made it quite clear that given the amount of documentation which paragraphs 2.1 to 2.4 contemplated, it would be impossible to comply with it. And one understands why there was an anticipation within that period of 48 hours.
Well, I'm not sure that I understand that, as we're not talking about physical objects.
Yes.
I would have thought it would have taken 30 seconds to delete the file. Doesn't matter how many zillions of pages there are. So, if you're entitled to the return as a term of art,
Yes, ma'am.
that's how long it'll take to perform the required act.
Indeed, my lord. We would have thought that in this modern world of technology, you plug in, you strike a button, you retrieve. But I don't know what were the complications. It may well be that the files were kept in different format, my lord, which required a technician to access this or that file, we don't know.
Well, you haven't addressed the technological dimensions, and let's not look for more problems to resolve than we already have. But wiping a hard drive may well be part and parcel of what would need to happen if one wanted to, in an appropriate case, secure complete lack of access in any form. Obviously, any other copies returned, etc., etc. I'm not sure whether our jurisprudence is entirely clear to do in such circumstances.
Yes, ma'am. Yes. And one has looked at the latest cases, especially of this division, on that technological issue relating to cyber information. None of them, with respect, are helpful in this context.
Yes. But I'm not sure that troubles us unduly here.
No.
My initial concern was even if one assumes that it's appropriate to inhibit wholly or partially publication, the return aspect of the relief isn't really superfluous in the holistic assessment of the applicant's genuine anxiety. But in any event, let's carry on.
My Lord, I would ask your Lordship to go to page 08-7, paragraph 3.
Yes.
I skip paragraphs 3.3 to 4, my Lord. I ask your Lordship to go to paragraph 5. Deals with issuance of the rule 9, my Lord, on the terms set out in paragraphs 5.1. And that is the heart of the issue which was before the learned judge, which is now before his lordship. And it is whether the retained heir should be confirmed. And again, my lord, when I started, I had wished to explore the facts, and I'm grateful that your lordship understands that I'm not going to get there. What I wish to do, my lord, subject to your direction, is to explore the question of our jurisprudence on information in the hands of journalists, which a subject of that information asserts it should be returned or should not be in the possession of the journalist's field. And we know, my lord, that the is one which is expressed in absolute terms, my lord. They suggest that they are the best placed individuals to make an assessment whether a source of confidential information should be protected. And we would respectfully submit, my lord, that that proposition is made because our jurisprudence starts on a clear premise that journalists, like all of us, are subject to the observance of the rule of law. Secondly, my lord, Holomisa makes it quite clear that...
Sorry, what makes it quite clear?
Holomisa. Your Lord...
Yes, no.
Yes,
Holomisa and Kumalo.
It makes it quite clear that in our constitutional world, unlike others, my lord, there is not a primacy or ranking of constitutional entitlements and claims. Therefore, for instance, when one looks at the American jurisprudence on First Amendment, one must be careful because the jurisprudence there, my lord, makes it quite clear that the First Amendment is ranked higher than some of the other rights, but not in this jurisdiction law. And so you look at all of the conflicting and intersecting rights, as is often the case. His Lordship to ask your Lordship to consider the competing claims in the context of the facts and ask your Lordship to make a balance that respects both, my Lord, not the journalistic, my Lord. And that, my Lord, takes me to our heads. At section H, paragraph 35, my Lord.
Page
35 of our heads. It is 12-45, my Lord. And my Lord, what we wish to do is to ask your Lordship to consider the submission we made in paragraph 115. And that submission, my Lord, is based on the Bernstein judgment, which describes what private information protectable under the Constitution is. And it is described as the inner sanctum of a person, such as his or her family life, sexual preferences, and home environment, which is shielded from erosion by conflicting rights of the community. We emphasize conflicting rights of the community. And we don't understand anything said in the respondents or the amicus heads to be disputing this proposition, my Lord. Therefore, my Lord, we would ask the Lordship to apply that proposition in Bernstein.
Well, let's just get some geography around this proposition.
Yes,
Is it too simplistic to approach it in this way? When a person's confidential information becomes, through nefarious reasons or otherwise, available to others, there are three broad categories. The one is in the context of unfair competition, where that contaminates the use by anybody. The second category is the category of intimate information, best illustrated by the Chabalala and Simang case. And then the third category is everything else. Is that a sensible way to approach this?
With respect, my Lord, we would align ourselves with that approach, my Lord.
So if we're in the everything else situation, what I see here is a contest between two institutional entities about business information. I'm not going to be too precious about whether in any serious sense every business document is confidential, but let's assume that they all are. So when you say there's got to be a balancing in that category, must it then follow that the entitlement, if that's not too strong a word, to business activities of entities would enjoy a stronger publishable attribute than otherwise. And is that then where we are?
Indeed, my lord. And my lord, I would emphasize two things that I think of as standing on my feet, my lord. The first is that in that context and in relation to that category of information, my lord, it is information relating to corporate relationship, not only of the Moti Group, but third parties elsewhere, who are part and parcel of that confidential realm of information. And they too have an expectation draws the balance. One needs to take the protected disclosures legislative instruments board, including section 159 of the Companies Act. That section protects a person who makes a disclosure, even based on confidential information, and shields that person against professional detriment. Should that happen? That is a balancing exercise drawn by the facts, not for one of the parties in litigation to assume the superior knowledge of drawing a balance mode. And
well, assuming that, however circumlocuciously it's put, it can't be a proper statement of our law that a journalist has the last word on whether something satisfies that test or not. Then what's the practical way to balance the function of the press and the degree of protection which you say is in the public interest? Must special court open to second guess journalists every time they need to publish something?
Lord, we would submit that can hardly be approach. Can hardly be the approach. Your Lordship would see, and the case we cite, they make it quite clear that it's a case-by-case analysis. And so your Lordship would look at the facts of this case and see precisely what is the balancing interest that your Lordship should be engaged in on the facts of this case, without formulating a rule which binds any court going forward in the context of different facts, my Lord. And I'll come to the facts in a moment, my Lord.
Well, just before you step off that, I mean, isn't that the problem, is that it's hard to think of a sensible systemic solution to whether in Tom, Dick or Harry's situation, publication should or shouldn't follow. So, one or other view, isn't it solved by what the about these things? Isn't that the way it's resolved?
Well, my Lord, if you look at the publication, it is the publication of the excerpts of information from which the journalists draw their own conclusions and around wrongdoing in relation to the conduct of the Moti Group. And they refuse to disclose the whole set of information around which the publication is going to be based, on the fundamental basis that so they assert, if we do, we will reveal our confidential source code. So your Lordship, on the facts we would submit, would have to consider whether or not that form of asserted justification has been shown on the facts. Because an element of media protection, my Lord, relates to protection of confidential sources. Without that element, my Lord, there can hardly be suggestion that your Lordship would be intruding into the sacrosanctity of media publication. So on the facts, your Lordship would look on whether or not this vital component which has detained our courts on protection of confidential information is one which is present here, so as not to disadvantage the media.
Well, let's just try and get a concrete understanding of that. So, a journalist gets it into his head to publish something which says that X is a crook. And we've already established that proper journalistic practice would be to put that proposition to X before publication.
Yes.
So he does that. He says, I'm in mind to say that you're a crook, that you did this and that. What do you say about it? And X then says, where do you get this from? And the journalist then says, well, I'm not going to tell you where I get this information from. You've got to admit or deny. You'd say that that's improper.
Well, my lord, I would be hesitant to make a submission based on a broader proposition which goes beyond the facts of this case.
Well, the thing is, I'm trying to locate it in the analysis.
Yes.
In this case, if I understand it,
Yes.
journalist went to the applicant and said, I want to make this following disparaging statement about you in a newspaper article, and I'm relying on documents of your own.
Yes.
What do you say about it? And the applicant's answer is, give me the documents. Give me the documents of my own that you have got. I don't want to engage with you until I've got them. So I'm seeking assistance on what we can demand of journalists. To be too demanding is pointless.
Yes.
To be too generous is not to strike the balance correctly. But if, as is put by the respondent, they are under ethical constraints to behave in a particular manner, a particular methodology which gives the right of reply, what more should the courts impose on journalists in order to have a practical balance, as you suggest there should be?
The practical balance that we would suggest, my lord, here has a number of elements. Let me not commit myself to a number. Has a number of elements. The first is, your lordship would say, but you have information which on the facts is shown not to be of any interest to your journalistic activity. It's information which by law is subject to protection. Not even a source of information would be entitled to make it lawfully available to you. I'm talking about privileged information. That type of information is an information which we submit that on that approach, there is no need for the respondents to keep them.
But what if you're going to use privilege as an example? What about the proposition in SAA versus BDFM?
Yes, ma'am.
I'm not aware that proposition's ever been qualified by another court. That says that you can't rely on privilege once it's leaked out. That's tough. Hard cheese. I mean, must I distinguish that case, and if so, how?
Well, my lord, as I understand, and I don't think that BFM's case go that far, as I understand, privilege remains privilege unless it has been waived. In other words, if I, as the beneficiary of that privilege, don't waive it, it remains privilege. And for that reason, the fact that someone else, in this case, we can fairly make the proposition, Mr. Fanika tried to waive that privilege, is irrelevant because his duty is to protect it.
Quite right.
And so, my lord, we would submit that on that score, the onus would shift on the respondents to show that their continued possession with a view to future publication of that information would serve a journalistic purpose of informing the public. And we would submit, my lord, that on that score, the justification rests with him. And
Well, assuming that that's a correct proposition,
yes, my lord.
that no matter what, a journalist must have a proper reason for publishing anything.
Yes, my lord.
And the more sensitive the information, the more compelling the reason ought to be.
Yes, my lord.
But that doesn't help us by characterizing what has come into the possession of the journalist. Whether it's intimate information or privilege or so forth, might give rise to a different series of considerations.
Yes, my lord.
But the real problem is this, is once the cat's out of the bag is shredded.
My lord, subject to this, that you are entitled as the person who is in custody of the cat to control the consequences that flow from it.
Well, I'm so.
Well,
I understand you to be arguing that that proposition can be derived from several norms.
yes. Yes, my lord. Yes, my lord. My lord, may this be a convenient moment to take your lordship to the judgment that I'm tempted to deal with out of
Please.
a sequence. It's that judgment of the English courts in British Steel Corporation, my lord.
Yes.
My lord, we have prepared a bundle of authorities for your lordship's
Yes, hand it up to me. I think I've got it in the respondent's bundle as well. Hand up your bundle, please. I take it your bundle's paginated, is it?
My lord, I believe that in the respondent's bundle it starts at 435, my lord.
Yes. Right, let me go there. 409, I think. British Steel,
Indeed, my lord.
16-409.
Yes.
What's the passage you want to look at?
The page, the passage that I'd like to highlight for your lordship, purely as a matter of factual context, is at 435, my lord,
Right, I'm going there.
under the heading motion, my lord. And I won't waste anyone's time on it, my lord, save to make this point.
435, heading motion. .435 is the beginning of Lord Denning's judgment.
Indeed, my lord.
Okay.
But your lordship would recall that that case started in the High Court, and I think Lord Justice McGarry was the judge in the High Court, my lord. And Grenada lost in the High Court. They went to the Court of Appeal, my lord, and Lord Denning sat as a member of the Appeal Court, and ultimately it went to the High Court, my lord. There was one dissenting judgment in the House of Lords, my lord, as I recall. But the facts are fairly clear, my lord, and I'm not going to belabor them, but they are instructive in this case, my lord, because they too involve an ex-employee who appropriated or misappropriated information and made it to a television station, Grenada in that case, my lord. And Grenada sought to engage in its journalistic activities by running a program on the so-called steel papers, my lord. And they too, like the respondents in that case, a senior member of British Steel Corporation to participate in the TV program presented around those documents, my lord. And Lord Denning had some words to say about how they treated the senior executive who appeared in the TV. But the point of the matter is they were trying to extend a right of rebuttal to the senior executive. But they did so in circumstances where it was quite clear that they were running their own narrative. opportunity, the executive a fair opportunity to respond, my lord. And in the end, my lord, they could not justify their continued possession of information. And what was interesting in that case, and it's something which is raised here but obliquely, my lord, and I'm not going to ask your lordship to reflect on it, is that once the papers were in the hands of Grenada, they started to interfere with them, my lord. And they started to deal with them as if it's their own information, it's their own documents, my lord. Lord Daniel reflected on that matter too, and concluded that it was an act of interrupting or interfering with evidence, my lord. But the point is, my lord, in that case, British Steel Corporation and Grenada, like the respondents in this case, my lord, sought to protect their source of information. And what the court had to do was whether compelling the media to reveal their source of information in that case would be a fair balance in order to protect both the right to confidential information and pursuit of journalistic activities, my lord. My lord, I'm going to give your lordship certain references.
Yes.
And I'm not going to take your lordship through them. Regrettably, I worked on the official report, so I'll give his lordship both the official report references and the hard copy references that your lordship has.
Thank you.
The first, my lord, is the official reference at page 436, B-D, my lord. And the second reference, my lord, My lord, I believe that that passage 436B-D, your lordship would find it at page 435 to 436 on the hard copy references.
Thank you.
And the next reference, my lord, is at 438, opposite letter H to J, under the heading Demand for the Papers, my lord.
Yes.
It's at 439, my lord, on hard copies.
So have it.
And then the next, my lord, is 439 C-D under the heading The State of the Papers.
Yes.
And the two last references, my lord, is at 441 under the resulting principle, my lord. And that is 442 on the hard copies, my lord. And then lastly, my lord, is at 442 B-D, applying the principle, that is the heading, my lord. And my lord, here with your leave, I'd like to read this passage because we would submit, would reflect the balancing exercise that we ask your lordship to do. I have been much troubled whether Grenada acted with due sense of responsibility. Many things they did are disturbing, not so much in the decision to use the information in the public interest, but in the way they went about it. True it is that they did not pay any money to the unnamed informer. If they had bought his disloyalty with a bribe, it would have put them out of court at once. At any rate, out of this court. But they did something equally irresponsible. They made an unfair use of this confidential information. Counsel for Grenada admitted that it was blatantly unfair. They might have to disclose the name. I think it was. It is most unfortunate that they left it so late to tell British Steel Corporation, and they did not give Sir Charles any opportunity to see the script before he got to the studio. I have also described the conduct of the interview by the commentator. It speaks for itself. It was deplorable. I hold that Grenada did not act with due sense of responsibility. The rest is there, my lord. We would submit, my lord, that on these facts, your lordship has uncontested evidence that the source is a former employee of the applicants. The source has stolen the documentation. The source has made the documents consent available to the respondents, my lord. The respondents have not given the applicants and their actors a reasonable opportunity of rebuttal. The respondents have not acted with that sense of responsibility to make available the documents which and need for them to properly and meaningfully respond to it. And it is inappropriate in the context of this case to suggest that you're doing so because you wanted to protect the source consent. And, my lord, once that is clear, that on the facts the respondents cannot persuade the lordship that they are proceeding with possession and publication of the information, when it is clear that the alleged source is no longer confidential, they cannot rely on a Section 16 right in absolute terms. And so, my lord, I'm not going to ask your lordship to look at the judgment of the House of Lords because it confirms.
Yes.
But all I can say, my lord, without any fear of contradiction by my learned friends, is that all the lords who upheld Lord Dennin's judgment did so in terms which are far more scathing than Lord Denning did. And so, my lord, we would submit that on the facts, the balancing exercise in this case commends the protection of the information, which is privileged, private, confidential. And, my lord, I will be quick in referencing key parts of our heads without repeating them. My lord, at page 12-48, from paragraph 120 to paragraph 126, we deal with repeat myself, my lord, and from page 12-50, my lord, from paragraph 127, we deal with confidential information, my lord, up to paragraph 139. Again, my lord, I have nothing to add in that regard. And at 12-54, paragraph 140, we deal with the question of the respondent's assertion that they're entitled to retain the documents, my lord. Again, I've addressed that issue, my lord. Unless your lordships ask me to deal with any further issue, I'm not going to deal with it.
Thank you.
And, my lord, from page 12-55, we address the question of the source, my lord. And at paragraph 151, my lord, we highlight paragraph 54 of Judge Soka's judgment in Bosasa, my lord, which makes the point that the respondents are not entitled to a blanket reliance on privilege, my lord. And we would submit that that judgment, my lord, still stands as good law because it has been confirmed by the Constitution. And we don't have friends suggesting that Judge Soka got the law wrong in the light of proportionality. With respect, we would submit that the Constitutional Court has affirmed the judgment of Justice Soka, my lord, in terms in the amaBhungane case. And then, my lord, in paragraph 154, we deal with the exercise which has been drawn by the European courts, my lord, in the Goodwin case and the Telegraph media case, my lord. And we would submit, my lord, that is not far from Justice Soka. In fact, Justice Soka referred to the Goodwin case in his judgment. I don't remember whether he referred to the Telegraph case. He may have, but I don't. The point is, he also referred to the judgment of Lord Denning in the British Steel Corporation case. And we would submit, therefore, that the European Court on Human Rights did was to assert that principle of. And again, we reference the Canadian Supreme Court case, my lord, from paragraph 156 of our heads. And finally, my lord, we make the proposition that if one has regard to and the affirmation of Bosasa in amaBhungane case of the Constitutional Court, it becomes clear that there is no hierarchy of rights in our jurisprudence.
There's no debate about that.
Indeed, my lord. And therefore, unlike respondents, engage in that exercise of balance exercise. And what we wish to add, my lord, by way of our oral submissions, having looked at what the respondents have said, my lord, is this: that when your lordship undertakes this balancing exercise, your lordship would bear in mind the foundational value of our Constitution, which is the rule of law. And the rule of law is important because we know from the judgments of the Constitutional Court that it's a foundational value which informs the interpretation of the rest of the Constitution and other law. And for that reason, your lordship would take it into account as a guiding tool in assessing the balance in this case. First principle of the rule of law, which we affirm in our oral submission, is that everyone has a duty to obey the law, including Mr. Van Niekerk, my lord. He is an attorney and would know better that as an attorney, if he would want to rely on protection for disclosure of confidential information, he would have to do so within the confines of the law. He would have had to act in terms of Section 159 of the Companies Act, or Section 5 and 7 of the Protected Disclosure Act. After all, the rule of law required him not to take the law into his own hands. And so, my lord, in this case, it is quite clear that Mr. Van Niekerk did the opposite. He did not seek to claim protection of the whistleblower legislative instruments. And we would therefore submit that any suggestion by the respondents that Mr. Van Niekerk was a whistleblower, and for that reason he deserves confidential protection, my lord, by them not coming on record to say that he's the one who gave them that information, would not be justified on the facts, my lord. Secondly, my lord, we emphasize the fact that the respondents have made it quite clear that what they have is not the mere set of initial documents on which they published information, the articles, sorry, my apologies, the first 4 articles. They make it quite clear that they have a trove of the Moti files that they wish to rely on and publish in the future going forward. And it is that fact of future publication that is of concern to the applicants, because it will relate to publication of matters that are private, confidential, and privileged. And for that reason, the applicants are entitled to approach your lordship and say, we seek judicial protection, because we are told by the respondents that they are the ultimate bearer of a decision on what is permissible and not permissible, my lord. Want to operate in that constitutional free zone, my lord, we would submit that the rule of law binds them. They have to act within the remit of the rule of law, my lord. And, my lord, lastly, we would submit that if your lordship, for some other reason, has concerns that the return of this information to the applicants would deprive the journalists to engage in a fair and legitimate exercise of journalistic reporting, your lordship should consider a balance that protects the information and make sure that both parties have access to it for the reasons that they may want to look at that information in order to assert their interest, my lord. And in that way, the balance would be secured to give the respondents the right to report legitimately as they wish, at the same time observing their responsibility to treat the subject matter of the reportage fairly, my lord. And lastly, my lord, I would ask your lordship to look at what the respondents say, and I'm not too sure how our learned friend they're going to persist with the proposition. They suggest to his lordship in their answering papers that the journalists have responsibilities that are ethical and professional, and when they act inconsistent with those responsibilities set out in the press code, then the press council has exclusive jurisdiction to deal with complaints journalistic duties under the code, suggesting almost, my lord, that his lordship's jurisdiction is excluded to inquire into that issue, my lord. With the greatest of respect, we would submit that that is wrong, my lord. The press council has no exclusive jurisdiction to determine fundamental issues relating to the rights and obligations of parties under the Constitution. Section 165 tells us that your lordship has the primary functions and duties to determine that issue. It is before his lordship, my lord. My lord, I think that I have said what I wanted to say orally. The rest of our submissions are there in writing. I would leave Mr. Stratton to make some few submissions on the well-known cyber crime and privacy legislation, my lord. I believe that Mr. Ceciliana would not make any submissions in the light of the view that his lordship has taken on the counter application.
Thank you. Thank you, John.
My lord, the rest of the submissions, I'll make them in reply.
A short break. Can we resume at 12:05, please? Adjourned. straight in. Carry on, please.
As your Lordship pleases. Lord, I'm going to deal with one other aspect before I deal with my topics, and that is the question of, the Lordship posed two questions to my learned colleague and leader relating to firstly the SAA matter, the West End, and I'd like to address your Lordship on those aspects. But primarily, before I go there, I'd like to deal with what served before His Lordship Mr. Justice Holland Newton, which was an application which disclosed in paragraph 12.8, case 902-8.
Let me go there.
That the respondents were in possession of certain confidential documents. Now, perhaps I can just deal with the SAA matter at this stage. As I understand your Lordship's point in that case is, and I think your Lordship said once the bag has been shredded and is out, then there's nothing confidential anymore. But that's not an all or nothing proposition.
Well, I don't think that's a correct statement of the proposition. The proposition means this is the confidentiality of information describes a relationship between the information and the owner, let's call it that. But once there's been a dissemination, the owner is no longer in a position to protect the confidentiality. Therefore,
yes, my Lord, but does that then mean, and if your Lordships had regard to the confidentiality affidavits, there are two of them which served before the for reasons, obvious reasons, I'm not going to list them.
Don't need to do that.
I invite your Lordship to have a look at those documents in there. You will see there are a lot of personal documents relating to people. There are a lot of other documents. The moment one ascertains or determines that documents have found their way to one set of parties but are not, does that then mean that the owner of those documents or the owner of the data or the incorporeal information, which I will tend to persuade your Lordship brings it within the realm of a physical document, is no longer entitled to assert a right of confidentiality going forward? So, for example, if we are talking 100 documents and A has stolen from B 100 documents but has only disclosed in the public domain 20 of those documents, does that mean that one cannot assert the right to protect or obtain the return of the other 80 documents? Surely the answer there must be no.
look, the first mountain you've got to climb is that trying to attribute to the respondent for Nikkert's culpability, whether in delict, in contract, or in criminal law, is something that will need a little bit more work, I suspect.
Well, my Lord,
But the problem is that this debate is at cross purposes with one another. I assume that Nikkert is a skullduggerous so-and-so. Take that for granted. The answer really is, so what? If I understand SAA and BDFM, and maybe I'm the last one to know what it really means, but I certainly think I understand what Judge Willis said in Avula, which is where the proposition rests, on a case on all fours with this. My question to Mr. Maleka was, how did Judge Holland Muller distinguish that proposition when he decided that he could give you this order? That was what astonished me.
well, my Lord, there was reference made to the Cybercrimes Act and the fact that these documents were on our submission as when I say I'm talking obviously of the applicants, are documents which it is not disputed were obtained by rigorous and nefarious matters, and the respondents have made themselves party to that conduct. Because Mr. May writes a letter to the applicant's attorneys, and he says that my clients have come into possession of these documents, and if one has regard to a conspectus of the papers as a whole, every time the applicants have asked the respondents to engage with the facts, they simply refuse to do so, and they put up the notion of the confidentiality of the source. And that must be seen in light of the fact of the acknowledgement in paragraph 4.1 of their own affidavit.
Well, Mr. Malek has dealt with that. I don't think we need to go over that. If you are wanting to deal with my criticism of how this ex parte order was obtained, which on the face of it seems to have been without full disclosure, then tell me that my impression that happened is incorrect.
Your impression with respect is incorrect, my lord, because we say that Waste Tech versus Wade Refuse, for a start, authority for the proposition, particularly in light of the Cybercrimes Act, that one cannot assert a right of ownership or a return of incorporeal data or incorporeal information. Waste Tech versus Wade Refuse was decided back in 1992, and it dealt with a situation where, in the confines of Anton Pillar law, His Lordship, Mr. Acting Justice Saruria, was confronted with a situation where the applicant could not establish a proprietary right in the it is probably best made by His Lordship is when he says at page 837, and Your Lordship, forgive me, there are so many references to different authorities.
Well, just give me the page in the case report.
1993, volume 1, essay at page 837. He says the South African courts have therefore no jurisdiction to grant an order for the attachment of the property of another, where no right of the applicant therein exists, merely for its production as evidence. He goes on to, then there's a discussion of whether there were copies made. Then there was a debate between Mr. Nugent, who appeared for the applicant, and there's a reference to various documents, and His Lordship then says at page 842 that the judgments referred to don't suggest that the action to restrain the use of confidential information is based on a proprietary right.
Yep.
That is back in 1992. Fast forward to the year 2022 or 2021, and the enactment, and maybe even before that, the Copier Act, Electronic Communications Act, and we deal with this at some length in the heads, my lord, the Cybercrimes Act. Now, before I deal with the Cybercrimes Act, I just want to also quote to your lordship something that is said in the British Steel case, in the judgment of His Lordship, in fact, Watkins, and once again, your lordship will forgive me for having a different bear with me. Can I come back to the reference? Can I give your lordship the passage in the meantime?
Well, that can come any time. Let's move to the sharp end. In the context in which you're picking up the proposition I asked assistance with to Mr. Maleka, I saw what was in your heads. I don't see any disclosure of the case law against your case there. I understand that ought to have been put. I'm asking whether or not it was.
It was not. We did not refer to Waste Tech and we did not refer to...
Well, then that's the end of that. There's no point in doing a post-mortem on that.
And your lordship will also recall that the matter, in fact, had some history. In fact, it came before your lordship. Your lordship said that it should go to the urgent court. It was brought as an ex parte.
Yes.
And for the reasons as set out in the heads, we prevent...
You don't have to, you want to talk to me about cyber security and so forth. Maybe we should go there.
Which lordship was, Lord Justice Watkins said was as follows. It says, if legal constraints are needlessly placed upon the activities of journalists, they will tend to become undesirably circumspect about their methods of seeking knowledge. Sources of it will be inhibited from passing on what they believe the public ought to know through fear of losing their anonymity. The promise of confidentiality going from journalist to source may become untrustworthy. This state of affairs must not arise. If it does, it would react intolerably against the public interest. And then this is the important point. On the other hand, the journalist, like everyone else, must live and work within the law of the land. If he does not, and a claim is brought which the court will entertain to force him to disclose his sources of information, these consequences are, in my opinion, likely to follow. If he commits a crime in concert with his source when obtaining information, even though this be done to expose inequity about which the public ought to know, his claim to press immunity should be denied. If he commits a civil wrong by using confidential information to which there is no right of access from a source whom he knows to have obtained it in breach of his contract of employment with an employer against whom no iniquity is alleged, his claim to press immunity will be very unlikely to succeed in the face of competing public interests, that of doing justice to the wronged employer. One then has a stated intention on the part of the amaBhungane journalists in DM15 these documents. We want to ask you questions on the disclose the confidentiality of our source. We say that horse is bolted. And we say that that horse is bolted because the Cyber Crimes Act makes the amaBhungane journalists party to the unlawful conduct. And also, I'm not going to read to your lordship our heads at paragraph.
Well, let's go to your
5.
Sorry.
Case Lines, volume 1278.
Right, let me go there.
In fact, let me go a page earlier, 77. The Cyber Crimes Act. And for this, we ask your lordship to assume that if conduct is a criminal offense, then the person against whom, or the person who has the right to assert the offense, has the right to take civil steps to protect their position. Now, and what we submit to your lordship is that this act does what is now obvious in the age of the internet and memory sticks and documents is it recognizes that much of business and much of information and much of documentation is not stored in physical form. Your Lordship will look around this courtroom and see any number of laptops and iPads as well as hard copies. But the point is, it specifically extends the ambit of what constitutes a document. And we say this to your Lordship for the following purpose. In paragraph 213, a copy of the Cyber Crimes Act is in your Lordship's authorities bundle, and we ask your Lordship to have regard to that.
Yes.
Reference is made to an article as including any data, etc. Data means any electronic representations of information in any form, data, message, etc. Person, over the page 12-78, means a natural or jurisdiction. Then we go on to section 3, and section 3 is important, my Lord. And what we submit to your Lordship, paragraph 4.1 of the respondent's answering affidavit, Mr. May's letter, where he says that he now represents amaBhungane, which referred to, all of this is referred to in the documents that served before his Lordship, Mr. Justice Holland-Mehta. Says, I represent, they have got documents and they are going after Clinton for them. And their failure to engage with the facts only by virtue of the fact they say we can't do that because we'll disclose our source. It's very easy. All they had to do is say we didn't get them from, or we don't have them, or we're not going to use them, or in the furtherance of our journalistic endeavors, we are going to separate out all these documents which have no journalistic purpose, as envisaged by Section 7 of POPIA, but we get nothing. Section 3 says, any person who unlawfully and intentionally intercepts data, let's call him Mr. Fanika. What does intercept mean? 2154 says, for the purposes of this section, interception of data means the acquisition, viewing, capturing, or copying of data of a non-public nature through the use of a hardware or software tool. So this is what Mr. Fanika has done. It then says, any person, at 2, I'm going back, who unlawfully and intentionally possesses the data or output of the data with the knowledge that such data was intercepted unlawfully as contemplated is guilty of an offence. Lord, that puts amaBhungane squarely in the focus of that section. But even if it doesn't, subsection 3 says, any person who is found in possession of data in regard to which there's a reasonable suspicion that it was intercepted unlawfully, and who is unable to give a satisfactory exculpatory account of such is guilty of an offence. Now I'm paraphrasing that. Now remind your Lordship of what his Lordship Justice Watkins said. So, what served before his Lordship Mr. Justice Holland-Mehta is a wholesale downloading interception of documents, and it doesn't fall within the realms of the Cerebros versus Wade Tech debate that served before his Lordship Mr. Acting Justice Saruria, or those cases. Even the case involving His Lordship Mr. Justice Willis predates the Cybercrimes Act, which was only put into effect in December of 2021. My Lord, I've looked for authority on it. At best, I have found a tutor's quarterly review, which effectively does exactly what I'm doing before your Lordship this morning, which is summarizes the points. Now, then, I think our learned leader has already referred your Lordship to the discussion of His Lordship Lord Denning in Mulholland's matter. But the point is this: it's not an absolute right to disclose. Even where we say that when weighing up the competing rights, there's an old expression that says, my freedom ends where your nose begins. Freedom of the press, freedom of the media, freedom of expression has to be balanced. The applicants went before His Lordship Mr. Justice Holland Mutter. Evidence that all of these documents had been stolen. And I say stolen by Mr. Fanico. Not one of them was ever made available to the applicants or Mr. Moti. My Lord, to my submission, it's no different to me cross-examining a witness. Saying to the witness in the witness box, I have a document in here in my possession which implicates you in some fairly serious stuff. I'd like to ask you questions on it. The witness says, will you show me a copy of the document? And I say, no, we all know what we're talking about. This is exactly what happened here. My Lord, it goes further, and at 214.4, 1281, we once again rely on the dictum in the House of Lords Grenada television, and to the extent that I'd given your Lordship the incorrect reference, it's now struck me that the proper reference is 1981 1 OER 417A.
Sorry, again, 417.
Yes.
Okay.
Then,
and the quote was, well, I found it anyway. I marked it.
It's in our authority.
Yeah. No, I've already got the Watkins quote and marked it. Yes. No problem. Yes. Let's carry on.
So then one has this whole idea, what is the basis for the right to publish? And leaving aside for the moment, without getting into arguments on what's in the public interest or what the public merely find interesting. We all know what that is. As your Lordship aptly pointed out, probably every journalist has Bogashi tattooed on some or other part of the body. There's a distinction. But the point is, what is in the public interest is in itself a concept which makes it newsworthy. When we know who the source is, and the applicants write to the respondents and say, give us the documents you're going to publish on so we can comment on them. Your Lordship this morning, the outset, said we don't need to add another floral to the cake with regard to the affidavit that came in last night. If your Lordship had allowed us, we would have shown you the whole article in which Mr. Moti said a whole host of things about that, like my children's birth certificates, blood results, etc., etc. So there's always a context when it comes to documents. If you're going to publish without giving the recipient the documents on which the publication is going to be based, when there are 250 companies, Ameti is the gatekeeper of those 250 companies, And it has an obligation, and I'm not going to argue the Popio, your Lordship knows what Popio says. If your Lordship has regard to the confidential affidavit, you'll see there are ID documents of people there. There are employment contracts there. There are all sorts of things. Give us our documents. Because you can't hide behind the confidentiality of the source when you have made yourself a party to that source's behavior. If you had given us the documents, if you had said to us, what we will do is we will separate out those documents in respect of which there is no journalistic purpose, we may not be in front of your Lordship today. But the point is that was not the attitude. It was, as I think, and I can't take credit for this statement, somewhere in our heads we say the approach adopted by the respondents and the amici in this matter is that the press is effectively allowed to operate in a constitutional free zone. And we say that cannot be the case. And when we went to court on an interim ex parte urgent basis, it was to say, please stop publishing. Because we knew this was going to bring about a reconsideration of these rights. And the facts and the evidence, and your Lordship will know that the first confidential affidavit, I have it here, it has over 4,000 documents. I'm not going to read anything which will make the applicants guilty of further taking stuff into the public domain, but it contains personal information of a host of people that work for and are associated with the Moti Group. It contains a number of confidential and trade documents. And that case is made out in the founding papers. There's reference, and it's almost a case of, well, if you say too much about exactly what it is when you're claiming confidentiality, you run the risk of exactly what your Lordship found in the SAA matter is now you have in fact shredded the bag and let the cat out, which is why we didn't do that. But then importantly, what we submit to your Lordship is, we say at paragraph 220, 12-82, and this is amaBhungane's characterization of the documents, not the applicants. They call it a trove of leaked internal documents. That phrase pops up time and time and again. And then, of course, in line with modern Twitter handles, feeds, hashtag Moti files. They end off their last article, which we annex to the founding affidavit, with what is effectively a watch this space. The last statement on page C189, this is now the last document. Our journalists are continuing to work on follow-up articles in the Moti files. We know who your source is. Give us our documents, or at least identify them for us so that we can comment on them, because there may be context. No. Then the question as to whether, because this is the respondents make something of us, they say that Raven Licata relief, you could have never come to court, and I think your Lordship's reference to Waste Tech versus Wade Refuse is aimed at that, is how does one then read section 12 of the Cybercrimes Act, which says the common law offence of theft must not be interpreted so as to exclude the theft of incorporeal property. Now, when one steals incorporeal property, and we submit, Your Lordship, that the way one must read incorporeal property in light of this enactment is it includes data, etc. And in fact, tying that back to what His Lordship Mr. Justice Sororia said in the Wastec versus Wade refuse case, he specifically says, if I can find the point, he says, Your Lordship will bear with me. At page 843, when he talks about the Titius's poem, and he says, in Justinian's Institute, it is said that if Titius has written a poem, a history, or a speech on your paper or parchment, you, and not Titius, are the owner of the written paper. Then he says, I am not aware of any decision in South African law in more recent times in which it has been held that information, whether confidential or otherwise, is the subject matter of proprietary rights at common law in the absence of statutory protection under intellectual property statutes. We have exactly that. We now have a statute which says one must interpret the common law crime of theft so as not to exclude the theft of incorporeal property. So the only question then is, how does that happen? Is it the confidential affidavit does with reference to each of the identificatory strings? Your Lordship knows that you have a drive, then there's normally a directory, and there are a number of criteria which will identify what a document is. I don't want to say any more about it, but it's there, Your Lordship will see it. If I do that, and I go away with a copy of that document, can it be said that all I've done is taken a copy? And Your Lordship's point earlier was, well, you haven't really been compromised because it's not suggested that you don't have the documents. We do have the documents. Whether when I say we, the applicants, whether the applicants are able to identify the documents with reference to a number of questions which simply say there are oblique references to in evidence in our possession, to documents, to know exactly what is being said, the answer must surely be no. But the question is, my act in taking a memory stick and downloading a copy, does that not amount to a theft of a document which brings it within the purview of Section 12? And there's a specific reference to the Cybercrimes Act in the founding papers with reference to how this theft was uncovered. Now, amaBhungane has failed to engage with the facts. At every turn of the way, they simply put up as a trump card the confidentiality of their sources. Your Lordship now has an opportunity in reconsidering the matter afresh to ask yourself, in light of these submissions, whether there was enough and that served before His Lordship Mr. Justice Holland Mutter to grant an order which amounted to a temporary cessation on publication of articles. And by the way, my Lord, not all articles. The order is specifically couched in terms where it is limited, because we don't know. We think we have evidence which is now set out in 2 confidential affidavits for your lordship as to precisely what was taken. But it's only that we ask you not to publish on. They could have come back and said, right, if they are to be the gatekeepers of journalistic entitlement, as they so bravely pronounce in their heads, say we lay no claim to these documents or we don't have them. But don't say nothing, because then the applicant's version must prevail. Because if you say nothing, but you rely on a trove of internal leaked documents, documents in our client's possession, there's reference in one of the articles to Mr. Van Niekerk that 2 or 3 weeks ago he may have been in trouble. Witness protection now. There's not a scintilla of evidence that he's in witness protection, my lord. He could have come forward. I don't want to argue what my learned leader has argued about the Whistleblowers Act or that. We simply don't know. All the evidence shows is that amaBhungane has made itself party to theft of documents, and when most reasonably the applicants have engaged and said, "Do you do know these are stolen documents, can we see them?" Their only retort to that is in DM 15, case lines 0398, where they say our client declines to provide you with such documentation. This is apart from anything else because it may reveal the identity of confidential sources. That is it. If it has lost the right to invoke the confidentiality of its sources, either because the source is no longer confidential, or because it has made itself party to the theft, then it cannot hide behind it. My Lord, the remaining submissions I have made, and then I just draw your court's attention to what was stated. I think it's a judgment of His Lordship Mr. Justice Binns Ward at page 12-91 of our heads of argument. There's a quote at paragraph 260 dealing with the applicability of waste tech. And there is a case made out in the Thawning papers on a number of bases. Confidential information, trade documents, trade secrets, personal information, but we don't know what. We've given them a golden opportunity. We gave them both confidentiality affidavits. They come and they say nothing. And they will all say that their rights are sacrosanct and they're not obliged to reveal their sources. And that is why your Lordship should not find for them.
Thank you for that. Mr. Buttenden?
Lord, approximately 2 weeks ago, a man named Daniel Ellsberg died. Daniel Ellsberg was an American, and he was the American who leaked the 7,000 pages called the Pentagon Papers. He was employed by the Department of Defense, and he breached his duties to the Department of Defense and almost certainly committed a crime of espionage and various else in leaking his papers, these papers, to the New York Times about the Vietnam War. That leak and the disclosure of the Pentagon Papers led to illegal countermeasures by the White House to discredit Mr. Ellsberg, to halt the leaks of government information, and attack perceived political scandal, which led to the disgrace and resignation of President. But some of those leaked documents that was denounced by the government. But the US Supreme Court stood firm and upheld the right to freedom of expression. We know and we don't know why they leaked. Just as we don't know on the applicant's own version, they say they don't know why the Mr. Vandikat leaked. If it was him, they say they don't know. Well, we don't know why the Gupta person leaked. Whether he'd been wrongfully fired or whether he was having an affair with someone's wife. We have no idea. But what we do know is that those leaks, those unlawful leaks, were published, and they exposed to public light and public scrutiny the extraordinary wrongdoings that were committed by the Gupta family and that led deep into the heart of the government. Now, I'm not suggesting that these cases that I've mentioned are identical to this case. Of course they're not. Every case is different on its facts. But what those cases demonstrate is that the simplistic approach proposed by the applicants, which says, if you steal a document and you give it to the press, then you and the press are guilty of a crime. More we can go and get an order to that effect without even citing you. That is an extraordinary proposition, and it is one that is incredibly damaging in our current democratic state. After all, if they were right, then the Guptas just missed a trick. The moment there was first a mention of the Gupta leaks, they should have run off to court, they should have got a Moti type order, as is the case here, and everything would have been just fine. But they didn't. Because the Guptas, either because they didn't think of this approach or because they were advised it was hopeless, didn't adopt that stance. So, my Lord, what I'm going to submit to you today is that today is in fact an easy case. There are going to be difficult cases on the margins, where there is an acute which meets an acute public interest, and the courts are going to have to battle those and determine our lines and our channels. But in today's case, the applicants do not even get out of the starting blocks. I'm going to demonstrate to you that on the papers before Judge Holland-Muter, and those are the same papers which matter today because they can't make out a case in reply despite their attempts to do so. On those papers, they haven't even ticked the box for establishing commercial confidentiality, let alone for establishing commercial confidentiality that outweighs the duty of force protection that was established in Bosasa. So, my Lord, in the course of this address, we propose to address the following issues in turn. Firstly, we will address the ex parte issue and demonstrate that the ex parte application was a patent abuse and should never be countenanced. Secondly, we're going to deal with the question of the order to return the documents and explain that for 4 separate reasons that order is not tenable as a matter of law. And finally, we're going to deal with the interdict against publication and make clear that it doesn't even begin to come home on cases that are 20 years old, like MIDI television and the cases that have embraced it. But before turning to those 3 issues, let me make 3 general points. The first is that, as I will demonstrate to you, our learned friends have both purported to address the ex parte nature of the application, and neither of them have justified it, but I will return them. The second is that whenever our learned friends were pressed or ran into trouble in relation to your Lordship's question, they resorted to effectively arguing the counter-application. You had references to discretion, to the limited disclosure regime, to Crown Cork, to the confidentiality affidavit, by which they mean the second confidentiality affidavit, which is filed on the 15th of June. All of this has taken place. So, whenever they run into trouble, they resort to this question of balancing and measurement and discretion and the confidentiality for Judge Holland-Muter. because none of it was part of the founding papers, and I'll demonstrate that to you in a moment. And the third point I would make is that it's clear at times what their real concern is. Their concerns vacillate. Sometimes they say they want to get the documents back so they can identify the leaker. Well, if that's the case, it is patently impermissible. But sometimes they say their concern is not so much about access to the documents, it's to make sure that the publication stops. They want to make sure that there are no stories published. Well, that's honest, but it's not a lawful basis because they haven't come home under MIDI television. So whether you view the case as an attempt to uncover or whether you view the case as an attempt to stop the reliance on the leaks, in either event, their case must fail. But let me turn to the first of my three topics, and that is the ex parte application. We have addressed the ex parte application and the principles which are required to be met in such an application in our heads. We do so at, I'm going to give you a Lordship paragraph references if that's
Yes, please.
at paragraphs 55 through to 68 of the heads. I will not read that to your Lordship. Your Lordship knows the law well from the SAA BDFM case and the other cases. But what is important is that your Lordship put to our learned friend Mr. Maleka the question, but can you explain to me why this application had to be brought ex parte? And we listened carefully, and the best we could understand was that the answer was this was very important to his client, and his client wanted to make sure that this stopped. I hope I'm not doing him a disservice, but I couldn't understand any argument that was put up as to why this was genuinely outside the genuinely fell within the ex parte application. And we submit that there is none, and you know that there is none when you read their heads of argument on that point. I'll deal with the ex parte point in their time. And I'd like to briefly take your Lordship there because it really is quite revealing. Excuse me. So they start at 189 and they say that that there's this contention of abuse, and they deny that it's so. And then at 192 through to 190. I'm looking for my learned friend's main heads of argument.
You're citing paragraph now.
I'm citing paragraphs. Yes. I could give your Lordship the page.
No, sorry, I was a bit slow. I'd forgotten you decided to do that. Yes, I've got it now. Thank you.
Thank you, my Lord. So at 189 to 191, there's just an introduction. And I'm doing this because I need to try and do justice to their argument and demonstrate that it's without merit. Then very bare chronology. And then at 202, we finally have something approximating argument, which says, the article ends by stating that our journalists are continuing to work on follow-up articles in the Moti file series, an indication that further articles were being prepared, and the likelihood that Mr. Moti would not be provided with the documents on which those articles would be based, or that the documents would not even be identified. And here comes the argument. All the objective evidence held documents. Well, let me pause there. That is self-evidently not a basis for an ex parte application. The notion of an ex parte application to restrain publication is unknown in our law under a democracy. In fact, you have to give notice, even if it's only 2 hours or 3 hours, and that's why the urgent court on a Friday always used to get the urgent applications before the Sunday Times was going to, because you give short notice, but you give notice. So that is not a proposition which stands. Then we're told, if the respondents had given notice of the application, it is most reasonable to conclude that the further publication would have taken place in the interim. Well, that's not a basis for an ex parte application because, as I say, you're always entitled to go to court urgently to prevent publication, and you give notice. This aspect was pertinently raised in the founding affidavit as follows. Put differently, there's no reason for amaBhungane to refuse, and it appeared unless the intention was to hide the identity of the documents and use them clandestinely. That's again about further publication. And then at 206, Considering the manner in which the stolen documents were initially acquired and are now being concealed from the applicants in the Moti Group, it was reasonable for the applicants to have a real apprehension that if the respondents were to receive notice of this application, the information that they had been provided with would at very least be concealed. With great respect, my lord. What that means is that every time there is a leaked documents case and you write and say, please give them to me, and the other side says no, you can run off to court and get an ex parte order directing the return of those documents, because all documents, you didn't give them to us, therefore we can go ex parte. It is patently inadequate. And it makes no reference to the letter, which I will give your lordship a reference to, but which your lordship has already referred to, which squarely made the point that no ex parte application was justified. That is the letter to the founding papers. It is 0398, and I wish to refer to 2 pages. At 0398, paragraph 4.1, it's said by Weber Wenzel, my attorneys, to the extent that our documentation, not ending there, and then, because it then says, this is apart from anything else because to do so may reveal the identity of confidential sources. So that is a legitimate, well-entrenched basis to refuse to do so. Avusa says so. But then over the page, it says, 4.3, the only access of our client to the materials is via 2 secured servers outside South Africa. So they say we've got access to one of the servers. But beneath that, at paragraph 5, it says, we are concerned that the tone of your letter suggests that our client may be intending to your client may be intending to court application of some sort against our client. Our client is concerned that your client may be inclined to do so on an ex parte basis, which would, in the circumstances, be unlawful. We deny that there is application. But even if there were, in light of the facts set out above, there would be no basis for such applications to proceed ex parte. The ordinary requirements for ex parte applications are not met. Moreover, any relief granted against our client would seriously threaten our client's rights and obligations to freedom of expression and the media, including multiple ongoing investigations into a range of issues. It is therefore essential that our client is heard before any relief is sought, and if any such application is to be launched, our client requires it to be served on ourselves. We trust that you will heed this caution and draw it expressly to the attention of any judge that is approached. Now, why is that point made? Because in that earlier paragraph, 4.3, it is said expressly, in respect of the second server, our client and its employees have no intention to delete or destroy such materials. So you're faced with a situation where my clients respond and say, we're not giving them to you because of confidential sources. And we undertake via our attorneys that we will not delete them or destroy them for a year. And then they say, but what this means is that there is no basis for an ex parte application, and we trust you will heed this caution and draw it expressly to the attention of any judge that is approached. Now, my lord, I've read these papers. This letter was put before the judge, buried in this application. The letter is buried halfway through, plus the confidential affidavit. I can't find anywhere in the affidavit which expressly says we were told to draw this caution to your attention and we hereby do. I can't find anywhere in the heads that says this is what they say. There are references left, right and centre to all sorts of things, and they say they give an undertaking, but the undertaking is not good enough. I would have thought that this should have been front and centre. But to make it worse, they then do not tell, and our learned friend Mr. Stratton has quite properly conceded this, they do not tell the judge about the decision in Wastec or the decision in Avusa. And when your lordship says implicitly, why is it? Your lordship says, why is it? And your answer is given as the following. It seems, Wastec is no longer good law because of the Cybercrimes Act. Now, if that is the argument, and the argument is bad on then the proper thing to do that it was wrong. and the South African Law Reports, page 406, paragraph 44 to 45. And there what the court says is, lower courts must be careful not only to pick the a reference to the founding affidavit, paragraphs 2.5 to 3.5. But we now know that that is false, or more charitably, mistaken. Because you will see from the next sentence of the heads that in the third non-confidential if I could read to you, qualified confidentiality the court say means it must be current. Says it must be public knowledge, it must not be public knowledge. Must be of economic value to the person seeking to protect it. The nature of the information is irrelevant if it complies with the requirements stated. Is that when you come to court to say this document is confidential, you must establish the three requirements set out in Unlawful. Or you must establish that it is truly personal in a different sense. And I'll come to the birth certificates and the rest. But you can't wave your hands across a bench full of 4,000 documents and say, it's all confidential, it's all personal. It doesn't work that way. And the problem is that the founding affidavit failed miserably on this score. Because when you read the founding affidavit, there are two affidavits. There's the big, thick affidavit in which the letter is buried, which says in very broad terms, things are confidential. The broadest, vaguest terms. And then there's the confidential affidavit, which lists the 4,000 documents. But there is no attempt to meaningfully bring those documents, the documents they know about, within this standard. Now, I accept there will be difficult cases again on the margins, where I know Ms. Goodman has taken documents from me, and I don't know precisely what there is, and so I might need to be more vague. But here they give a list of documents, but they don't demonstrate that they are confidential. How do we know that they can demonstrate it? Because there was some suggestion, well, it's too difficult to demonstrate. Well, we know they can try. And we know that from the second confidential affidavit, which is the one filed on 15 June. Because it's that affidavit that our learned friends keep referring to. Every time you hear about a birth certificate or a child's school report or anything like that, that's not a reference to the first affidavit. The document might be there somewhere, but the explanation is in the second confidential affidavit. And that affidavit is too late. It's called the second confidential affidavit, but it's filed with the reply. And you cannot go off to urgent court, get an ex parte order of extraordinary proportions, and later fix up your case and reply, whether you call it a counter-application or otherwise. So, with respect, you keep getting told, it's unbelievable that the respondents don't at least tender the birth certificates, they don't at least tender the this, they don't tender the that. Well, my lord, if the case had been brought to say, you have the following 10 birth certificates, why they're on a Moti server is a different question, but you have the following 10 birth certificates. They belong to children, they must be disclosed. We might be in a different case. But instead what you have is an absolute failure to make up confidentiality, first time round, an attempt to do so second time round, and my clients say, we were deluged with this, we didn't have a chance to answer, so my clients haven't even answered that confidential affidavit. So now say my client's trying to hold on to child's birth certificate. I mean, with respect, it's not an argument that deserves a serious response. So, where are we, my lord? The re vindicatio doesn't apply. End of the order. There's no showing of ownership on their own version now. End of the order. There's no showing of confidentiality. End of the order. So before we even get to the delightful constitutional issues, which I would love to spend all day arguing about, they've got to make out a case. They are the applicants, they are bound by Plascon Evans, they, the applicants, must make out their case. And the applicants have not done so. And let me lastly say on confidentiality before I move to the fourth point, they need to do more than say these documents were confidential. They've got to say they are confidential. That is why the language of Mr. Justice Southwood in the second requirement says they must not be public knowledge and public property. And that is what links to your Lordship's judgment in BDFM versus SAA. They have to say confidentiality existed and it has not been lost. Even though the documents have been disclosed, not just to the press, but to Mr. Lutsky, so they say. That's their case. They must say confidentiality has not been lost. Without that, they get nowhere. So now let me turn to the last point. And the last point is where they want to have the debate, because make no mistake, and you see this from the papers and what Mr. Moti is quoted as saying in the papers, not referring to this morning's affidavit, I'm referring to all the other things he said. This is an attempt to say the media need to behave. He says so in words of one syllable. So that's why we've had so much argument on that score. But when you go there and have a look, we've dealt with this at paragraphs 84 to 93 of the heads. And at 84 to 93 of the heads, we deal with the principles of source confidentiality. I do not need to spend time on them, my lord. If your lordship give me 1 moment. Just a reference. We do not need to spend time on them. Your lordship knows them well. It's your lordship's own judgment in amaBhungane that was endorsed by the Concord in the Rika case. What I need to deal with is this straw man of an argument which is created, which says that what the media's case is that they have the right to make a call on whether that's in the public interest, and that means they are a law unto themselves. Now the argument is half right. The media does assert, and that's what that passage in the affidavit says, the media does assert that it's for the media to determine whether the documents that they are in possession of is in the public interest and whether they should retain them or dispose of them. Of course that's right. But that doesn't mean that they are a law unto themselves. On the contrary, if the media gets it wrong, then they are liable to claims for damages or interdicts or anything else. But what you can't do is say that any time someone who comes and complains about a document, suddenly the court must now engage in a sifting mechanism through 4,000 documents. There is no precedent for that. Certainly not the example which keeps getting given about unfair competition. Because in an unfair competition world, the reason why the court has that special procedure is to make sure that the confidentiality is not lost. It's got nothing to do with the same sorts of considerations that are in this case. So, this is not the media saying they are a law unto themselves. It's the media saying it is their right and duty to make a call on whether a document and its publication is in the public interest, just like it is the media's right and duty to make a call on whether a defamatory allegation should be published or not. No one says that deprives the courts of jurisdiction. It's the media who must make the call, but if they get it wrong, then the consequences are calamitous for them. And that's why we have cases like Boboshi and all the rest. So, the whole premise is wrong. So we now come to the actual source protection. And we've heard everything from, well, we know who the source is. Well, with respect, my lord, we know who the applicants think the source is. My clients have deliberately and quite properly avoided saying whether it is Mr. Van Niekerk or not. And the suggestion is, well, if it's not Van Niekerk, you should just deny it. Well, with respect, what kind of game are we playing? That means that every time someone wants to know about a source, you bring an application, so the source is A, B, and C, and if they deny A, B, or don't say anything about B, then you know it's B. It's, with respect, source protection would go out the window. So the argument that somehow it doesn't matter because we all know who the source is without any merit. The second argument, my clients have been at pains to adhere to their ethics and their duties to do so. The second argument that you've heard is to say, well, Mr. Van Niekerk engaged in unlawful conduct. He was not driven by public interest or civic duty. He was not driven by a desire to reveal unlawfulness and criminality. And quote, unquote, we don't know what his motive is. Now, with respect, my lord, I don't know what Mr. Van Niekerk's motive was either. But I can tell your lordship that it was irrelevant. Because whether Mr. Van Niekerk, just like the Gupta leaker, had a good motive or a bad motive, that is not determinative of what is in the public interest. And let me say that that is made clear by an authority that our learned friends put on, and one that our learned friend referred to in his address. If your lordship would have regard to their heads of argument, it's the European Court of Human Rights decision. It's the decision of the European Court of Human Rights. It's at paragraph 155 of their heads. It's the Telegraph Media Nederlands decision.
Yes.
And what it says is, and this is their quote, while it may be true that the public perception of the principle of non-disclosure of sources would suffer no real damage where it was overridden, in circumstances where a source was clearly acting in bad faith, with a harmful purpose, for example, by intentionally fabricating false information. Courts should be slow to assume, in the absence of compelling evidence, that these factors are present in any particular case. In any event, given the multiple interests at play, the court emphasizes that the conduct of the source can never be decisive in determining whether a disclosure order ought to be made, but will merely operate as one, albeit important factor, to be taken into consideration in carrying out the balancing exercise. So this suggestion that the moment Van Niekerk is assumed to be the source, the moment he's acted unlawfully, that somehow taints the respondents, is just a suggestion without any merit. At best for them, it is one factor, but the trouble is that our learned friend Mr. Maleka concedes quite properly that we do not know what his motive is. Well, with respect, if you can't even know what his motive is, how can you possibly say his motive is so ill and foul that it should be attributed to amaBhungane? There may be cases where one knows what the motive is. He's employed by a competitor. The competitor has a desire to leak. Whatever. It's not this case, and you were told that that's the case. The third point that I need to make on the source duty is the repeated reference to the Steel Granada case. Now, we understand why our learned friends wish to refer to that case so repeatedly and enthusiastically as they have. But the problem is that the references to the case miss a fundamental point. That case was decided in 1981. 15 years later, the European Court decided the fundamental case of Goodwin, which has been referred to 15 years later, the European Court of Human Rights decided Goodwin versus the United Kingdom, which expressly dealt with source protection and really introduced it to European freedom of expression law for the first time. Goodwin is, of course, incited by our various cases, including in Bosasa, and it's been cited all over. And it is indeed, even our learned friends cite Goodwin. But if I could just, thank you. If I could just read to your lordship what was said in Goodwin at paragraphs 44 to 46. This is at 17-672 of case lines. 44. in this respect, it is true, as Lord Donaldson put it, that an injunction would not effectively prevent publication to Tetra's customers or competitors directly by the applicant's journalist source or the source's source. Unless aware of the identity of the source, Tetra would not be in a position to stop such further dissemination of the contents of the plan, notably by bringing proceedings against him or her for recovery of the missing document, for an injunction against further disclosure of him or her, and compensation of damages. Tetra also had a legitimate reason as a commercial enterprise in unmasking a disloyal employee or collaborator who might have continued access to the premises in order to terminate his or her association with the company. In other words, the European court saying this was a case in which they wanted to know who it was so they could get rid of him or her, because otherwise he would continue leaking. Not this case at all. These are undoubtedly relevant considerations. However, as also recognized by national courts, it will not be sufficient per se for a party seeking disclosure of a source to show merely that he will be unable without disclosure to exercise the legal right or avert the threatened legal wrong. And then the court goes on and says you've got to consider all of the requirements, including the overriding requirement of the public interest. In sum, there was not, in the court's view, a reasonable relationship of proportionality between the legitimate aim pursued by the disclosure order and the means deployed to achieve that aim. The restriction which the disclosure order entailed on the applicant's journalist's exercise of his freedom of expression cannot therefore be regarded as necessary in a democratic society for the protection of Tetra's rights under English law, notwithstanding the margin of appreciation available to national authorities. Accordingly, the court concludes that the order requiring the applicant to reveal his source and the fine imposed on him for having refused to do so gave rise to a violation of his right to freedom of expression. So, Steele versus Grenada is decided in 1981. 15 years later, the British courts follow Steele versus Grenada, only to be overturned by the European Court of Human Rights, even though the margin of appreciation existed on the basis that it wasn't sufficiently protective of the source. So with respect, Steele versus Grenada must be treated with extraordinary caution. And one of the reasons it must be treated with extraordinary caution appeared from the language that our learned friends read. There was language in that case which said one of the terrible ways in which Grenada Television treated the Steele Corporation is that they invited him on the show and they didn't give him a script in advance of what was going to be said on the show. Well, my lord, if it was our law that carte blanche had to give a script every time they invited someone on the show, my attorney, Mr. Milo, would have a heart attack. That is not our law. It has never been our law. And the fact that the court thought that that was an appropriate standard for a responsible journalist suggests that a case decided 35 years ago, 45 years ago, 40 years ago, should not carry great weight with this court. Then we come, and I apologize for the sort of bitsy way of dealing this, but I need to just knock these points and then we can summarize them. Then we come to this contention about Bosasa. And you are told, well, look how wonderfully the Mail and Guardian, Mr. Basson, behaved in Bosasa, because they just discovered the documents and refused to disclose the source. And in this case, there's no disclosure of the documents. My lord, I was in Bosasa versus Basson. That case was not remotely similar to this. It was a defamation action launched years after. And it was in that context that there was a debate about whether to disclose the documents. You can well understand that in those circumstances, the journalists would disclose the documents because, firstly, the time for risk to the story has come and gone. Secondly, presumably, the time for any risk to the source has at least ameliorated. And thirdly, it was felt that it could be done without disclosing the identity of the source. That's why the Bosasa-Basson case was an attempt by Bosasa to compel Mr. Basson to disclose the source. So it is as far removed from this case as possible, where this case the attempt is to try and stop the reporting, disclose the source, etc. Now, my learned friend Mr. Strachan says in response to that, we don't understand what the problem is, because it won't disclose the source. All we want is the documents. But with respect, my lord, we know what happened in this case. The reason that the applicants think they know who the source is because documents were sent by Mr. van Rensburg to the Moti Group for comment. Those documents were then the subject of a metadata analysis by Cianre Investigations, and they concluded on that basis that this is where the documents come from, and therefore we know the source. Now, whether they were right or not, the point of today's case. But the point is the suggestion that when you're just giving us documents, you're not disclosing a source, is patently bad on the facts of this very case. So, my lord, And lastly, our friend Mr. Stratton doesn't argue the Protection for Personal Information Act, despite all the repeated references in the papers and the heads. That's unsurprising, because as we pointed out, the media have an exception under the Personal Information Act. And very lastly on this point, we're told, well, Mr. Van Niekerk is not a whistleblower and he's not in witness protection, and therefore it means that the case on source protection is no good. Lord, it is patently irrelevant. It was never our case that source protection was only good because he was a whistleblower or in witness protection. It's never been our case, and it isn't our law. In Bosasa, there was no suggestion of having to bring yourself within the whistleblower protection or witness protection. And similarly in amaBhungane, in the Constitutional Court, the court made clear it was all confidential sources. It didn't limit it. So, my Lord, where are we? We're in a situation where what is asked to be disclosed are documents received by my client from a confidential source. We are in a situation where the order that is sought would require my client to give up documents given to them by Mr. Van Niekerk. How much could be clearer that it's an attempt to reveal the source? We're in a situation where the papers make clear that Mr. Moti's aim in bringing this litigation was partly to reveal the source. Lord, we are nowhere near the difficult case. Even if you assume the re vindicatio applies, even if you assume that there's no showing of ownership, that there was a showing of ownership, even if you assume that there was a showing of confidentiality, we are nowhere near the difficult case. It's an easy case, and on easy and ordinary principles, it is patently bad. I'm sorry, my junior corrects me very helpfully.
Take your time.
It's not that Cianri did the assessment, it was assessed by Mr. Paul O'Sullivan. He was the one who did the assessment. And Cianri did the assessment of what in fact Van Niekerk took. But the point about metadata is correct. So the point is that it was the documents which revealed the metadata, or are said to have revealed the metadata. So if I could just correct that. So, my Lord, on the second leg of the case, is there any basis to order the return of the documents? No. There wasn't in front of Mr. Justice Holland Muter, when you understand the principles properly, but there certainly isn't in front of you on these papers. That then leads me to the third leg of the case. And the third leg of the case is the interdict against publication. And I can be very brief on this, my Lord, because the applicant's case waxes and wanes depending on what they think would be of assistance to the relief. Sometimes their case is a privacy case. Sometimes their case is a defamation case. Let me start with the privacy case. If their case is a privacy case, you have private documents, you may not use them. Well, I've already explained why the privacy case doesn't get out of those starting blocks. So that case is plainly bad. But even if the privacy case were good at that level, it's clear that private documents is not a general basis to interdict publication. On the contrary, the Financial Mail versus Sage makes clear that the public interest is critically important. And I'll come back to how you balance in a moment. So if their case is privacy, that's not they can't even start, but even if they could start, they can't end, because the point is public interest matters a great deal. If their case is defamation, they've got an even greater problem, because their case on defamation would have to be, these are the passages which are defamatory. These passages are defamatory of the applicants, not somebody else, the applicants. That's so. 1, they're defamatory. 2, they're defamatory of the applicants. 3, they are unlawfully defamatory of the applicants. In other words, they're false or whatever basis. They don't even get out of the starting blocks. They do not identify the passages. The most that they do is they say the articles are one-sided. With respect, my Lord, one-sided might be all sorts of things, but it's not an unlawful defamation. They then say, well, we needed to be heard. We had to have a right to respond, and you only offered us excerpts of the document. Our learned friend, Mr. Stratton, compared it to a witness who doesn't get given the document. Lord, the appropriate analogy is different. The appropriate analogy is that you say to the witness, I know you've got a document in your possession. I'm going to give you part of that document. Could you comment on that? That's the analogy. They've got the documents on their own version. But in any event, the right to reply is not that kind of requirement. We've demonstrated it in our heads on the counter application. It is not a requirement of Bagoshi invariably. It's not even, this duty of make available everything you've got is not even part of our admin law, and we've given you the authorities for that. So the point with respect is just without any merit. And then they say, well, we rely on the Press Council and the Press Code, and our learned friend Mr. Maleka pours scorn on the notion that only the Press Council can enforce that. But he doesn't deal with the judgment we've put up, which is your Lordship's judgment, the judgment of your Lordship's brother in Matojani J, recycling and economic development versus Mnet, which we've cited in our heads. So they've got all sorts of problems with the cause of action. But let me take a step back and let me assume that the cause of action is good in one or more of those respects. They still haven't come home under the requirement for a prior restraint enunciated in MIDI television and repeatedly endorsed by our courts, including in print media. Could I just spend, and I'm almost done, could I spend one moment on what MIDI television is about? Because they say this is just a process order. Well, let me tell you what happened in MIDI television. MIDI television was a case in which ETV wanted to broadcast a program which contained interviews with witnesses who were going to be testifying in a criminal trial. Somewhat audacious, one might say. So ETV wanted to run this story about the Baby Jordan case, and they wanted to include interviews with the very people who'd witnessed the murder and who would become witnesses in the criminal trial. And the DPP, perhaps understandably, was outraged and went off to court and said, they wrote to ETV and they said, we want to see a copy of this documentary in advance. Because when we see it in advance, we'll know whether there's a problem. And ETV said, we don't give out our documentaries in advance. This is not the UK in 1981. We don't give out our documentaries in advance. Forget it. And so the DPP goes off to court and gets an order interdicting ETV from broadcasting the documentary, not indefinitely, only until they've given the DPP an advance screening. That's what the High Court held. The SCA in trenchant terms held that that judgment was untenable. It said that you could not require the media to give an advance citing to someone. But more importantly, that even if there was some fundamental issue like the administration of justice at issue, that did not outweigh the public interest in the unfiltered and unfettered flow of news. And it said again and again and again, Judge Nugent saying, the remedy is after the fact. In all but the most extraordinary cases, the remedy is after the fact. Why? Because we don't engage in prior restraints. And exactly the same principle was endorsed in print media. The Con Court expressly endorsed it, saying that you don't give prior restraints except in the most extraordinary circumstances. And Lord, let me assume against myself that there is somehow a cause of action on this leg, either privacy or defamation, or not given a proper right to reply. Nothing that is said makes this case so exceptional that it takes it out of the ETV or the MIDI television case. Nothing. And on that basis alone, the order cannot stand. If they had gone to court and said, if they hadn't sought the prayer about the return of the documents and they just sought an interdict, they would have been laughed out of court. But instead, because they bring in this return of the documents and buttress it and add this, somehow it becomes different. With respect, this case is a non-starter on this leg too. But Lord, I'm now going to turn to costs. Oh yes. My Lord, my learned friend Ms. Goodman was going to deal with a counter-application, but we don't propose to deal with it any further in light of your Lordship's view that it's not a problem.
I don't need to hear that.
Thank you. Our heads are there and they do deal with some helpful points on the matter. So my Lord, on the question of costs, there are three sets of costs. There are the costs before His Lordship Mr. Janssen van Nieuwenhuizen, which were reserved. There are the costs before your Lordship on the main application, and there are the costs before your Lordship on the counter application. We submit that all of them should be paid by the applicants, and they should all be paid by the applicants on an attorney-client scale, including the costs of two counsel. Well, Lord, I have never understood whether there is a difference between attorney-client and attorney-owned client. I've been asked to urge you for attorney-owned client. Let me be clear, we ask for the highest scale of costs available, whatever that may be.
Thank you.
But Lord, is there a basis for the order? We say unequivocally there is, and let me tell you why. Firstly, in respect of the ex parte application, it should never have been brought ex parte. And having been brought ex parte, it was not met with full disclosure. On that basis alone, attorney-client costs are warranted. Secondly, in respect of the proceedings before Judge van Nieuwenhuizen, where the parties ended up at Judge van Nieuwenhuizen's rather insistent urging, was they ended up on an order that had been proposed by my clients 24 hours earlier and rejected by the Moti Group. Well, on that basis alone, leaving everything else aside, the costs should be attorney-client costs, because the order was one that would have avoided the urgent court being troubled and would have avoided my clients having to send counsel to court. But thirdly, and in any event, this, my lord, is the absolute archetypal slapsuit. This is an application brought by corporations with deep pockets in an effort to intimidate the media into silence and to make it as difficult as possible for them to do their job. I don't have to tell your lordship about the judgments in Mineral Sands Resources, your lordship is well aware. I don't have to tell your lordship about the judgment in Morn versus Zuma, your lordship is well aware. But those judgments make clear that the right to approach a court under Section 34 of the Constitution is not a right to abuse that process. It says that a court must take steps to prevent abuse, and this is abuse. By asking what the litigant have done, if that reasonable litigant wrongly they had a case. Well, the first thing is they wouldn't have gone ex parte. They would have given notice, they would have gone off to court. The second thing is they wouldn't have tried to fix up their case in reply by filing second confidential affidavits, later third confidential affidavits, a counter application, which is patently without merit. But the fourth thing is, in truth, having seen the answering affidavit, they would not have persisted at all. Even if you the first answering affidavit before Van Nieuwenhuizen and AJ came in, and the second answering affidavit before you came in, the second litigant would have beat a hasty retreat. They did not. We are here. They have briefed 8 counsel. It's hard to imagine a more obvious attempt at bullying than this case. I speak not about the legal representatives on the other side. Of course, they are doing their job. I speak about the applicants. And we ask that the court make clear that this bullying is not what our courts are for. You can have a legitimate disagreement with the media, but you don't engage in this kind of conduct. And we would ask your lordship to mulct them in attorney-client or attorney-owned client costs. My lord, we have employed 3 different counsel, but we have engaged in a tag team effort. So we only ask for the costs of 2 counsel. As you will see, my learned friend Mr. Winks is away.
Thank you.
Lord, just to round off the point, just to make absolutely clear, the Cybercrimes Act, I'm not going to get into the weeds on for 2 reasons. A, it wasn't pleaded in the founding papers against my client. B, it doesn't change the case, because the debate about whether Mr. Van Niekerk breached the law in giving my clients the documents doesn't assist. And thirdly, it doesn't change the legal position on the Reivindicatie. So we can get into the weeds if you wish, but it seems to me, with respect, that it just doesn't take it anywhere. But I shouldn't be understood to agree or in any way endorse the submissions now made by my learned friend Mr. Stratton. We submit that they are quite wrong on the interpretation of that act, but urgent court is not the place to decide that for the first time, if it can be avoided.
Thank you.
Thank you.
We'll take a break now. I'm going to suggest we take a 20-minute break now. At 2:10.
back by 20 past 2.
And you said 10 points.
No, it's literally in one line. It'll carve out space for that to be
time here. So it's not
Yeah, I have. Well, on duty. In open court?
All rise.
parties on which we rely to paginate.
Then send it to. If you prepared a written, a printed one, I'd happy to have it, but let's not go to that trouble at this time.
My Lord, by way of a brief roadmap to our submissions, we don't seek to reopen unduly any debates that have been had before this court and intend to focus on 3 brief submissions. The first is the obligation on states, including the judiciary, to ensure an enabling environment for media freedom. The second is the harm of in-camera ex parte orders on investigative journalism, and undue restraints on the media. And the third, my Lord, is the essential role of journalistic sources for effective news gathering and reportage on public interest matters. My Lord, we have heard the submissions of both parties and only seek to complement those submissions where necessary. Equally, we only seek to introduce matters which are relevant to this court, and in doing so, through the course of our submissions, we will refer this court to 6 authorities, 3 international law documents, 1 domestic, 1 foreign, and 1 international law case, which really go to the broader context, my Lord, within which this matter needs to be considered. My Lord, we submit that the context, or the interpretive lens through which my Lordship should consider this matter, is particularly in relation to the heightened protections which need to be afforded to journalists, firstly, in their own right, to journalistic sources, and to the public at large, my Lord. We call these the 3 paradigms within which Section 16(1) of the Constitution applies. My Lord, in brief, and following on from the submissions made by Mr. Budlander, my Lord, there is an there's an obligation on the state to ensure an enabling environment for media freedom. My Lord, this obligation has 2 components. Firstly, my Lord, in General Comment number 34 of the United Nations Human Rights Committee, my Lord, the full citation can be found in paragraph 18(1) of our heads of argument. And for my Lordship's benefit, I'll refer to our paragraphs numbers for ease of reading.
Thank you.
But my Lordship, simply, in ensuring this enabling environment, the obligation must be fulfilled by the executive, the legislature, and the judicial branches of government. It includes in instances, as with the present matter, where acts by private persons or entities impair the enjoyment of the right to freedom of expression. And my Lord, we submit that this accords with Section 7(1), read with Section 8(2) of the Constitution. We note, my Lord, that the applicants rely on Section 1 of the Constitution in arguing that the yardstick in this matter is the rule of law. But we submit too that this court, if my Lord is going to pursue that particular argument, is equally to look at the obligations on the state in terms of Section 7(2) and 8(1), inclusive of the judiciary, to ensure that an enabling environment is created for press freedom. Now, my Lord, within the context within which Mr. Budlander closed his submissions, we refer this court to paragraph 20 of our heads, to the Joint Declaration on Media Freedom and Democracy. My Lord, this is a 2023 document, and what we seek to do in these arguments, my Lord, is really expand on what my Lordship referred to as the sacrosanct journalistic norms, which are applicable in this matter, but to give this court the most recent authorities in that regard. My Lord, this document was prepared by 3 special rapporteurs, 1 from the United Nations and 2 from the African Commission on Human and People's Rights. And while it does not constitute binding international law, it certainly falls within the purview of non-binding international law read in terms of Section 39(1)(b) of our Constitution. My Lord, here the mandate holders suggest that this positive element on states to ensure an enabling environment must have due regard to the work of journalists, and they do so in 3 parts. Firstly, the obligation includes measures for the safety of journalists and media workers, and for their protection from, importantly, my Lord, threats and harassment. Secondly, the obligation includes measures to protect journalists and media outlets from strategic lawsuits against public participation, SLAPP suits, and, my lord, the misuse of the judicial system to attack and silence the media. In particular, states should consider that legal proceedings against journalists that are brought in bad faith harm journalistic work and the operation of the media. And then lastly, as it pertains to source confidentiality, my lord, the obligation includes ensuring the full protection of confidentiality of journalistic sources in law and in practice. Any limitations on source confidentiality should be pursuant to clearly defined exceptions set out in law, which apply only where necessary to provide an overarching interest. My lord, in further complementing this obligation, we refer this court at paragraph 22 onwards to the Declaration of Principles on freedom of expression and access to information in Africa. My lordship, it's a document prepared by the African Commission on Human and People's Rights, and it suggests that the right to express oneself through the media by practicing journalism shall not be subject to undue legal restrictions, and that in order to protect this right, state must take measures to prevent attacks on journalists and other media practitioners, including acts of intimidation or threats undertaken by the state and non-state actors. So, my lord, on this point, the obligation to ensure an enabling environment is to ensure conditions in which expressive rights, which we refer to collectively as the three paradigms in which freedom of expression operates, and vigorous debate must be allowed to thrive. My lord, this requires an environment in which the media are able to exercise their right to freedom of expression and report freely on matters of the public interest without threats and without fear, intimidation, and harassment, including in the courts. My lord, we then turn to our second submission, which we deal with in brief as it has been dealt with by Mr. Budlander. But here we simply seek to bring this court's attention to a further resource. It's a report, a 2022 report, which was published by the United Nations Special Rapporteur on the protection and promotion of the right to freedom of opinion and expression, Ms. Irene Khan. My lordship, the citation can be found at paragraph 57 of our heads. And here, my lord, the report emphasizes that states, as well as private actors, are increasingly targeting journalists and news outlets with litigation in an attempt to intimidate or exhaust the resources and morale of journalists. My lord, the report goes further to note that forum shopping, gagging journalists, legal action with the aim of intimidation, and excessive defamation suits fall within the realm of legal and judicial harassment of journalists. And then lastly, this complex mesh of legal threats, legal restrictions, and orchestrated campaigns against journalists, among others, leads to a grim prognosis for media freedom and the safety of journalists. In seeking to cure this grim prognosis, my lord, Ms. Khan suggests and calls on states to end the weaponization of courts against journalists and to discourage frivolous or vexatious legal action against journalists and news outlets, and take measures to protect journalists and media workers from SLAPP suits. My lord, as briefly referenced by Mr. Budlander, the question of SLAPP suits was also dealt with recently in the Morn decision, and I seek solely to give my lordship a citation in this regard. It's Morn versus Zuma and others, 2023. It's a Safely citation, my lord. ZAKZPHC 59. and we refer to two portions of the judgment. One at paragraph 33, and the other at paragraph 113. My Lord, to the extent that my Lord is going to write in this matter, cognizant of Spillhouse, the first really reaffirms, and this is at paragraph 131, 133, my Lord, and here the full Peter Maritzburg division simply holds that the rights of journalists to report freely on matters of public interest without threats and without intimidation and harassment is included within the ambit of section 16(1) of the Constitution. My Lord, the second of the quotes pertaining to slap suits is found at paragraph 113. And here the full bench holds that it is quintessential to freedom of expression and freedom of the press to protect the abuse and the intimidation, censoring and silencing of journalists by means of slap suits. So, my Lord, these first two submissions of ours really give the context within which this matter has been brought, my Lord. We do not intend to make submissions on the facts between the parties, but to the extent that my Lordship is minded, these resources give this court international and domestic authority on the challenges and the increasing challenges that journalists face in seeking to do their job, my Lord. We submit that if journalists can do their job, and we say clearly there are two of our heads, journalists cannot do their job, or democracy cannot adequately function. Our submission is brief, and here we simply refer this court to the most recent jurisprudence of the European Court of Human Rights. My Lord, it's a February 2023 decision in Harlet, H-A-L-E-T versus Luxembourg. My Lord, the matter is referenced at footnote 37 of our heads of argument. My Lordship, this matter was 10 years in the making, and it ultimately concluded in the Grand Chamber of the European Court of Human Rights. It really extends what happened in the Goodwin decision. And my Lord, it is somewhat distinguishable from the British Steel matter, which has been cited by the applicants. My Lordship, we submit that this is the most comprehensive judgment on the sacrosanct principles of media freedom, including on the questions that are relevant to my Lordship in this matter around source confidentiality and determinations around the public interest. And my Lord, the reason we introduce this particular decision is we note that arguably in reply, my Lord, the applicants bring in the contention of a balancing of rights. They put freedom of expression against privacy, but seem to go no further, my Lord. To the extent that my Lordship is even going to get to the process of considering a balancing of rights, the Harlet decision provides clarity to my Lordship on how best to do so, particularly around the nuances that are required when balancing rights in the context of media freedom. My Lord, in this particular matter, an employee of PricewaterhouseCoopers in Luxembourg disclosed 16 documents to journalists. He was subsequently convicted of the crime of theft, and the matter was taken on appeal through a series of domestic courts, and thereafter ended up at the European Court of Human Rights. My Lord, the European Court ultimately held that the damage that Mr. Harlet had caused to his employer, PricewaterhouseCoopers, was not outweighed by the interest in the public having the information. This matter pertained to It had tax implications for PwC and the way they operated their business in and around Europe, my lord. And while the facts of this matter are not directly opposite to what my lordship is considering today, the principles at play may be helpful to my lordship in the balancing exercise. And I refer, my lord, to three portions of the judgment. The first, and this really goes to the nuance necessary in engaging in balancing exercises. The court considers it necessary to fine-tune the terms of the balancing exercise to be conducted between the competing interests at stake. Over and above the sole detriment to the employer, it is the detrimental effects taken as a whole that the disclosure in issue is likely to entail, which interfere with the right to freedom of expression of whistleblowers, which are protected in Article 10 of the European Convention. So, my lord, here the court causes parties arguing these matters to look at matters holistically. In a similar vein, PricewaterhouseCoopers raised arguments around reputation, around privacy. But the court asked the parties to look further and balance all competing rights and interests, not just simply the rights at play, but the interest in the disclosure of the documentation as well. In expanding on that particular point, my lord, the court goes further in saying, in the specific context of cases concerning the protection of whistleblowers, in which the disclosure by an employee in breach of the applicable rules of confidential information obtained in the workplace is the issue, the court focuses on establishing whether disclosed information is in the public interest. In expanding, in this connection, the court reiterates that the concept of public interest is to be assessed in the light of both the content of the disclosed information and the principle of its disclosure. Going further, the court says, as it case law currently stands, the range of information of public interest that may fall within the scope of whistleblowing is defined in a broad manner. And then lastly, my lord, and it's something that hasn't been introduced by either of the parties, but it bears resonance in this matter. My lord, if we look to some of the averments made by the respondent in their answering papers, and particularly at Annexes DM22, with the first two articles published in the so-called Moti file. My lord, here an additional element is brought in by the European Court, which is applicable here, is that the court would emphasize that the public interest in information cannot be assessed only on a national scale. Some types of information may be of public interest at a supranational level or for other states and their citizens. And publications regarding business activities of the applicant in Zimbabwe, my lord, there is an additional element for this court to consider, in that the public interest is not solely within South Africa, but too may resonate with citizens of Zimbabwe. My lord, the last case we seek to bring to my lord's attention is Globe versus Mail. My lord, it's a case of the Canadian Supreme Court. If I can give my lordship a citation.
I have it in your heads.
It's Globe versus Mail, Globe and Mail versus Canada. Brackets the Attorney General. It's a 2010 decision. And my lord, the relevant judgment starts at page 592 of the Supreme Court, Canadian Supreme Court law reports. My lord, in this matter, the Canadian Supreme Court ruled against the disclosure of a journalist's source in civil proceedings between the state and a corporation. The corporation, in a pre-trial dispute about prescription, sought to ask questions of a journalist that would compel them to reveal their confidential sources. The trial court allowed this. And if I may pause here, my lord, with reference to some of the submissions that were made by the applicants, it is true that a lot of domestic courts have found against journalists, my lord, on these particular types of questions. but what bears reference and where the relevance of comparable foreign and international law is apposite in this matter is that in the vast majority of cases where determinations were made against media freedom, those were reversed in appellate courts, either domestically, regionally, or internationally. In this particular case, and notwithstanding the allowance by the trial court to question the journalist on his sources, the trial court also between the corporation and the Canadian government. The newspaper appealed both the disclosure order and the publication ban, and the Canadian Supreme Court reversed both of those orders, my lord. So, to the extent that my lordship is going to detail fundamental principles which apply to media freedom, we submit that both the Globe and Mail, in addition to the Harlot decision, give my lordship the appropriate clarity on the current status of these fundamental tenets. My lord, then in closing, we seek to introduce the finding of Labelle J. It's L. My lord, this goes to the question my lordship posed to Mr. Maleka earlier about the question of second-guessing journalists and how intrusionary or otherwise a court should be in this regard. Lordship, here the Canadian Supreme Court gives my lordship guidance, and Labelle J ultimately concludes with the following observations: that a mere breach of confidentiality by a source cannot automatically be the basis to ban publication. In doing this, Labelle holds, I am reluctant to endorse a situation where the media or individual journalists are automatically prevented from publishing information supplied to them by a source who is in breach of his or her confidentiality obligations. Importantly, my lord, this journalist to verify the legality of the source's information. It would also invite considerable interference by the courts in the workings of the media. Furthermore, such an approach ignores the fact that the breach of a legal duty on the part of a source is often the only way that important stories in the public interest are brought to light. Imposing a publication ban in this case would be contrary to all of these interests. So, my lord, recognizing the positive obligation on states to ensure an enabling legal environment, the cautions expressed by Special Rapporteur Khan on the increasing weaponization of courts against investigative journalists, and cognizant of the findings in both Harlot and the Globe and Mail decision, we submit in our heads, my lord, that this matter should never have been brought. But now we're instructed to find the relief that is sought by the respondent in this matter, my lord. And we submit that even to the extent that this court is prepared to engage in a balancing exercise, which it may not need to, the rights to media freedom in this particular instance outweigh any other countervailing rights. We do not submit, my lord, that the right is absolute, but on the facts of this case, we submit that it should be given primacy. My lord, if there's nothing further from the court, those are our submissions.
Thank you very much for that.
My lord, I've got two submissions to make. The one is extremely brief, the other is not long. I'll start by referring the to his argument, which are at case lines 11-11 And our bundle of authorities is from 11/8/59. And like the first to third amici, we will happily email that bundle to your Lordship's registry. My Lord, Mr. Budlander made the submission that this is nowhere near a difficult case, and this was reminiscent to me of the last time that I heard such a submission was made by Mr. Budlander's father to the Constitutional Court, where he and I were appearing on behalf of the Joe Slovo residents in the eviction application. And he cheerfully began his address by advising the court that this was not a difficult case. His cheerful optimism proved to be unfounded, but he and I sustained a withering experience at the hands of the court, and the result was a judgment from the court with 4 or 5 different judgments, which it's impossible, or as far as I can establish, it's impossible.
Let's assume that this and a few others are really easy. But I think the point that I understood Mr. Budlander to raise when he made that remark is reminiscent of something that Judge Willis said is this in fact a suitable set of facts upon which to lay down or give voice to pronouncements of fundamental importance?
My Lord, in our submission, important issues at stake, which it would be extremely helpful, not just for the immediate parties to this case, but for litigants more generally, if the court were to address.
No, I accept that, but let me put it in what I think is concrete terms. The ideal case for useful on the constitutional norms would be one in which there's a genuine agony on the part of the court between the grievance raised by an applicant and the freedom of the press. I'm not sure that this case is in that class.
My Lord, can I append that my response to that submission, and I've got a very brief second submission, and if I can
go ahead, please.
At that stage. Despite the unfortunate precedent of the Joe Slovo case, it's also in the respondent submissions earlier today, and we're able to get to the point at which they were anxious to engage, which was the balancing of rights, that even if they are able to get to that point, it is still not a difficult case, that the balancing of rights exercise is weighed heavily in favor of the respondents and the rights of freedom of expression. If I can just address the argument that was raised this morning. It was suggested on the basis of the Holomisa case that it makes it clear that there's no ranking of constitutional rights, and in contrast to the United States First Amendment jurisprudence, all rights of equal standing in this country, and they say that the clash between the competing rights must be resolved in their favor, and they argue that Section 159 of the Companies Act is not applicable, and the whistleblower, or Mr. Van Niekerk, we needn't get into details there, does not comply with the requirements for protection in terms of the Protected Disclosure Act, and the balancing of rights, the protection of the information of the private and confidential information in their possession and privilege. My Lord, the importance of freedom of the right to freedom of expression has been dealt with and in our heads from paragraphs 13 to 35. It's also been dealt with comprehensively in the respondents' heads of argument from paragraphs 11 to 30. I'm not going to traverse that ground again, but what I will do is refer the court to paragraphs 8 and 9 of the television case, the judgment of Justice Nugent, where he makes it clear that one is dealing with a balancing of rights in terms of not identical competing rights, but analogous, broadly comparable competing rights. Said that balancing process must take place in terms of the framework established by Section 36 of the Constitution. And it was noteworthy in the applicant's argument this morning that they spoke of balancing of rights, but nowhere did they address the conceptual framework within which that balancing of rights or proportionality inquiry must take place. And in light of the finding of in Medi Television that it's in terms of 36, I wish to refer to the court to the case of, it's not in our heads of argument, and if I can just give the court the reference, it's EFF versus the Minister of Justice and Correctional Services. It's at 2021, Volume 2, Essay Volume 1, and it's a Constitutional Court judgment, and it had to do with Mr. Malema's challenge to the Writers' Assemblies Act. And in the majority judgment, Chief Justice Macheng wrote at paragraphs 35 and 36 as to the approach to take. And given that if the balancing of rights argued for by the applicants must take place, given the importance of the framework that is set out in this judgment, I wish to read it to the court. The Chief Justice stated, it's necessary to give proper context to a Section 36 proportionality-based justification analysis. Whenever a fundamental right has been limited by a law of general application, it is required of the state or any party seeking to uphold the limitation to give good reason for a court to exercise that interference with a right so important. It is indeed correct that Section 36(1) does not expressly mention the importance of the right. This is a factor which must be taken into account in any proportionality evaluation. So, although there's no ranking of rights in our South African jurisprudence, for purposes of the Section 36(1) analysis, the justification or balancing analysis, one cannot ignore the importance of to have regard to in this passage. Then Chief Justice continues, for the right and the character or cornerstone of our constitutional democracy, both the nature and importance of the right must necessarily be taken into account, and the state has no inherent right to limit these rights, but it is constitutionally obliged to respect, protect, promote, and fulfill them. And moving on to paragraph 36, the values and principles that are essential to a free and democratic society must guide our courts. They are, after all, foundational to our democracy and the high and ultimate standard by which such a limitation of guaranteed rights may be reasonably justified. Only where the exercise of these rights would be inimical to the realization of collective goals of fundamental importance would their limitation be reasonable and justifiable in a free and democratic society. So again, I stress the collective goals and the principles are articulated there about the values foundational to our free and democratic society. And this provides the framework within which one must make the assessment as to whether the freedom of expression rights or the individual privacy, confidentiality or privilege rights are to be My Lord, the applicants have steered well clear of pointing the court to the articles which were published by amaBhungane, which precipitated these proceedings. They are I refer to just to the first of these. It's Annexure DM 22 at case lines 03. And this article focused on the Moti Group's links with the political elite in Zimbabwe. It was it was reference to a joint venture agreement where disputes where the current president of Zimbabwe and Mr. Moti were the parties to be elected to participate in the mediation proceedings as principals. There was an indication of the president's son being employed by the Moti Group, and there was, that's at 03-150, and there was an unsigned trust deed reflecting the Moti Group considered setting up a trust for the benefit of the president, the current president, and his family. And my Lord, one reads this and one thinks, haven't we seen this movie before? Isn't this script familiar? And it's eerily reminiscent of the evidence which was before the Zondo Commission and state capture and the role of the Gupta family in this country. And if one has regard to the importance of freedom of expression and the obligation to combat corruption, which is dealt with, and I'm not going to take the court, again, I'm not going to take the court there, it's dealt with from paragraph 37 in our heads of argument, and I referred to particularly to the quote from the Glenister 2 judgment at paragraph 40 of our heads of argument, which the majority judgment there stated that corruption threatens to feld at the knees virtually everything we hold dear, precious in our hard-won constitutional order. It undermines the democratic ethos, the institution of democracy, the rule of law, etc., etc. It's set out in paragraph 40 of our heads of argument, and won't belabor the point.
I'm not sure what the real implication of the submission is. We do know, and I suspect a court's entitled to take judicial notice of the fact that at this time our society is riven with all kinds of corrupt practices, and prudence tells us to be on the lookout for it all the time. But would the appropriate legal principle be any different if we were living in a society in which corruption was aberrant?
My Lord, the submission would be that given the context and...
Well, that's really my point, is the fact that we are in this does it mean there needs to be a new and more muscular principle, or is it simply important to be alive to the context when doing the fact-specific analysis, which wouldn't necessarily imply a different legal principle?
My Lord, if one comes back to the values underlying Section 36(1) and the importance of the rights at stake for constitutional democracy, one has regard to what Glenister 2 has to say about the effect of corruption on our democracy. And when one balances that with what we submit are not particularly clearly articulated private rights on the part of the applicant, that balancing exercise weighs strongly in favor of upholding And on the other hand, amaBhungane has an impressive track record of exposing corruption in the public interest, and the reference to that is to be found at paragraph 59 of our heads of argument in paragraph 50, and that's with reference to their work on the Gupta leaks, the McKinsey, and the regiment's investigations.
Yes.
My Lord, the second submission is brief, and it relates to the point that the question that your Lordship has just put to me about whether, in the fact that we live in a context of where corruption is rife, whether it justifies a heightened level of scrutiny. We make as the submission at paragraph 67 to 70, paragraph 67 to 70 argument that particularly when one is with regard to the balance of convenience requirement for an interim interdict, that indeed if there's credible evidence of corruption, then this should trigger a heightened level of scrutiny and weigh significantly in the balance of convenience evaluation. And it's motivated with regard to the outer judgment in paragraph 68 of our heads of argument, where the Constitution is underlying our Constitution, and in a manner that promotes the objects, spirit, and purport of the Constitution. And the court there, through Justice Moseneke, said that an important consideration where an interim interdict would restrain a statutory body from exercising statutory powers would be what it referred to as balance of powers harm. And that entailed an assessment of whether the relief would intrude into the terrain of another branch of government. And our submission at paragraph 69, building on the outer principles, is that if in an application for an interim interdict, which would be one of the issues before this court in respect of the reconsideration of the order granted on the 3rd of June, that in a case such as this application, where there's credible evidence that the respondents are seeking to expose corruption, that this should be a weighty consideration in determining where the balance of convenience lies. Those are our submissions, my Lord.
Thank you very much, Mr. Efron. Mr. Maleka?
is that there is a journalistic exercise of that I would like to address in reply.
A moment. Basis. And so when a Leonard analysis is not born they professed that only evidence is that Lord, I'm not going to trade with our learned friends for the respondents a motive argument the Watergate scandal, my Lord, or the Gupta-Gate scandal, my Lord. Because made remote those to conclude and accept the case that this case will emphasize one is that the respondent in the possession of the respondent and C has not been the kind of criminal offense that we have seen. What is also common cause, my Lord, and that's our second point of emphasis. The fact is that applicants have